May I please, Your Lordship? Lordship, with the consent of other side, Lordship, item number 44, Lordship. Kindly adjourn for today, Lordship. My senior is out of station, Lordship.
Number 44.
Yes,
Oh,
Lordship.
2015 method. Sorry. This court doesn't grant adjournment. You have to wait. We will see if the matter does not reach it. You are happy. If the matter reaches, and I think that the case is there for allowing it, I will allow it. Otherwise, you know the context. No.
The matter first of area salary 20 years weeks already passed since the date of notice, but till to the no response has been. Yeah, 1 month before the matter was listed here, but not this. That matter may be listed on 26.
Matter may be reached.
It's on next 26.
We will help it in 12th of June.
12th of June.
I have a prayer for item number 23 to 24 to 33. I need accommodation for today. Kindly today and tomorrow. Kindly take up on day after tomorrow.
Why?
Here we are led by the AG. But he is having some difficulty today. I have been instructed. Kindly take up the matter. I have taken consent of the commissioner.
Content doesn't matter which is called. I'm only concerned that you were only to find out. Yes, Mr. Roy, did you find out?
I have also not received the instruction.
Fantastic. So we'll call the director of textiles, personal preparation. Here issue this. Let us know if the central government is not helping us, so we have to know what is it. Because otherwise the petitioner, why he is not entitled to an interim order.
Lordship, let it be on Thursday, Lordship. Let me try, Lordship. I've tried, Lordship.
On
Thursday, Lordship.
Thursday, there are many matters. Then
if the instruction comes on Thursday.
we will take it as what they say, that man-made fiber would not come within the ambit of.
In absence of the instructions for Lordship, ultimately that is available on record. In absence of the instruction, but even they have said, I have difficulty for
Understood, but it was made on that day. Your AG categorically said that he is going to reply today. Didn't he say so?
Suddenly, because of
So the difficulty of the AG hardly matters. It's just when this court does not want or have not asked that the AG should be present, he appears in the capacity of a senior counsel.
From the side of the respondents, the instructions are there.
You say kita method. And this court doesn't appreciate this aspect of the matter.
But I undertake that if in case of any difficulty, there will no prayer for adjournment outside.
You have some other matters, na? Along with this,
Yes, my lord. 5 more matters.
you have the list.
My lord, I'll get. I have it.
This matter is same.
Same matter. My lord. Only the seizings were done. Seizure lists were prepared by the authority, and they have seized our goods.
It's okay.
Only deviation.
This is a consequence of it. It's only the consequence. You have the list,
Yes,
so I'll
I'll
list
just
it
get-
along with these on next week.
Finally, I'll just provide it within.
But otherwise, the fact is same
Facts is same.
as to whether they will come
Correct.
within the ambit of that
Absolutely.
order.
Yes.
That covers the law.
And you have only challenged the consequences.
Consequence. And your lordship wanted to know that the word included, how it has been interpreted by the Supreme Court. My lord, Orissa High Court judgment, which went to the Supreme Court, described the word includes. Now, my lord, here the Supreme Court says, if the word includes is there and that has been interpreted and an explanation has been provided, then the word would have a limited scope. Only will confine to whatever has been provided. If the word is only include and doesn't provide the meaning thereof, then it will have an exhaustivity. So, my lord, in that submission also, my lord, that is covered by the Supreme Court judgment. 1977 judgment Supreme Court. 1977, my lord.
You are saying about the pottery matter.
That pottery matter, absolutely.
But later on, I think recently the Supreme Court have gone into the aspect of includes and says that the includes means
Has an exhaustive.
it is more exclusive, but then also certain things which would otherwise not be there, but that has been brought.
Lord, that 19th May judgment, three judges of the Supreme Court, Justice D.Y. Chandrachud, that also have went, my lord. That says, my lord, in those cases, intention and the purpose of the legislation has to be seen in consonance with it. And whether the intention of the legislature was there to provide a meaning to it. My lord, even if the word meaning is not there, in those cases it says, even if the meaning is not there, but if they have sufficiently described about it, then they cannot put or add any other words to it. And that Punjab High Court judgment, which again went to the Supreme Court, Punjab Electricals matter, that also have gone through. There also, my lord, the interpretation for the Supreme Court says that it has to go word by words, each sentence by sentence. That is on a different aspect, but that also says on a similar line that when the meaning is provided, you cannot go beyond.
Give me that judgment on that.
Punjab
Yes, the latest judgment on that
of the Supreme Court.
and include
That's-
because a thing may not come within the ambit, but by the word include,
Includes.
they bring it within.
Within that. Correct.
Just for example, Mekhala Sadar may not have included certain other aspects.
Yes.
Just for example, those other, but that has also been brought in by the word
By the word
includes.
includes.
That is the scope.
Alphabet.
But the limit here it limits.
Here it limits because they have
In
provided
77, the Supreme Court it limits it and says that then you have to read it with ejidem generis and all.
Correct. Abunti clause.
You give the list.
I'll
We
provide
take it up on that day. Mr. H. Batala, the learned counsel appearing on behalf of Mr. D. Nath appears on behalf of the learned senior government advocate, appears on behalf of the state. Mr. S.S. Roy appears for the central. This court, by the order, last order to take, had asked Mr. S.S. Roy to obtain the instructions as regards the, that is Annexure 11?
J. Annexure J, page 79.
Annexure
J.
J.
Jammu and Kashmir.
Annexure J of the writ petition at page 79. However, no instructions have been received. Mr. H. Petala further submits that there are 5 other analogous writ petitions, which are, give the number. Lists the matter on 25/5/2023 for further.
Item number 4, we have filed in reply yesterday. Lordship, may be permitted to cross on report.
My lord, item 41, my lord. This matter, my lord, there was a direction on me to seek instruction as to whether any family pension was granted to the wife, my lord. And in this case, my lord, the petitioner's counsel is not appearing.
Which one?
Item 41, my lord. Virendra Kumar Baglari.
Hmm.
So, my lord,
Oh, that matter.
Then-
He has died.
died, my lord. Yes.
Hmm.
Matter has become infructuous, my lord. She is receiving. I have instructions, my lord, written instruction that she is receiving 70,500 from 2018. I have a written instructions, my lord. So, my lord will keep this matter in an upgraded thing so that I can place it, my lord. So, the matter has become infructuous.
You have the instruction in written.
Yes, right now.
We'll take it up at 2. We'll take it up at 2 because then only it has to be seen, nah? Because otherwise, if the petitioner counsel appears, you never know.
My lord, my lord.
Maybe I beg to mention for listing in competent government quarters matter, my lord.
Huh?
It was listed, my lord, 4/1/2022.
Or what?
Competent government appointment, my lord. Thereafter, it is not listed.
Compassionate.
Yes, my lord.
Very well. Go to court number 5. Right? Go there. I am not there on compassionate appointment.
May I please, Lordship? Lordship, I beg to mention item number 38, Lordship. We have been instructed to withdraw the rate petition, Lordship. So far, our information, Lordship, petitioner has got relief.
What is your name?
A. Alim Sheikh, Lordship.
You are not there.
Yes, Lordship.
Get hold of anybody who is there.
One on behalf of Mr. M.U. Mondo.
Huh?
I am on behalf of Mr. M.U. Mondo.
No. Get any of those 4 counsels who are there. If you want to withdraw, those person has to be for this. Or when the matter is taken, then you may submit.
My senior is, Lordship, in hospital, Lordship.
Fantastic.
Surgery, Lordship.
Get the other 3. Only one is there. Or remain when the matter is called. Then I can do it. In a mention, if I do it tomorrow, that person may hold you. You are a junior counsel. That is why I am telling you. If you are withdrawing a matter, thereby taking away somebody's right for redressal under 226.
Yes, sir.
And you are not authorized by a Vakalatnam. And tomorrow, if anything happens, you will be caught.
Lordship, then kindly adjourn for the day.
No, we'll take it up when the matter is there.
Obliged, Lordship.
It will be almost item number 4, 5.
Item number 1, promotion.
May please, Your Lordship. My lord, in this case, I pray for a week's time, my lord.
For what?
Because authority may not go ahead with this scheme, my lord. Consultation is there, my lord. Because
Understood, but then
during,
also-
during 2021,
No,
it was an
Mr.
important.
Goswami, kindly appreciate one thing. This court is not going to adjourn any of these top
Well,
of the list matters.
My lord,
Sorry, I can't
authority,
adjourn it.
authority
Let us see what is the matter about. We'll see.
contractual matter, my lord. Tender
Whatever
matter.
may be, let us, you see, this is a matter which has come up for motion.
Yes.
You should
My-
notice.
In this regard, may I submit, my lord?
Yeah. Let the petitioner,
2021.
what has happened? Petitioner is not there. Yes, whatever you challenge. Whatever you challenged.
May it please, Your Lordship. Lordship, I would adjourn when my senior is in hospitalized, Lordship. Viral fever, named here, Lordship. And previous not with me also, Lordship. JUNM, Lordship.
Huh? What about Mr. K. Agarwal? He has been all along appearing. There's a stay order.
Yes.
Mr. Goswami, what has happened to this
Yes,
tender?
my lord, may I submit, my lord? May I
Yeah.
clarify here? I think, my lord, 21/8/2001, my lord, matter was heard, if I am not wrong, my lord. And record was directed to be produced, my lord. Accordingly, you produced the record, my lord. And court heard the matter, my lord. In fact, the judgment was reserved, my lord.
That is okay, but you see,
For a long time, since it is pending, my lord, now due to change of configuration of the river and rate, my lord, authority is thinking over the matter, whether this is still viable or not, my lord. That is why I pray for a week time, my lord. Because at that time, it was an important scheme, my lord. But it was kept pending.
when can you get your instruction?
My lord, by a week. I am told, my lord, by the authority, the consultation is on.
So, but in view of the interim order which was passed,
My
nothing happened.
My, And my lord, the matter was not even thereafter placed before this honorable court, my lord. We mentioned it, my lord, for several occasions. Ultimately, on 15th May, my lord, record was handed over to us only.
Mr. Goswami, you see this particular list. There are 64 matters which are there,
My lord,
and all these matters have been assigned to me and Justice Chaudhary
my lord,
and Manish Chaudhary.
my lord.
All matters up till 2021, I am taking it.
But at that time, I think, your lordship.
I'll do one thing. I'll fix it next week,
Yes, yes.
and I'll issue notice and fix it next week, and then you get your instructions.
Yes, yes. No problem for that.
Heard?
J. Ghosh.
A. Ghosh, the learned counsel appearing on behalf of the petitioner. Mr. B. Goswami, the learned additional advocate general, who
1 to
appears
5, my lord. 1 to
appears
4, sorry,
on
1 to
behalf
4,
of
my
the
lord.
respondent number 1 to 5.
1 to 4, my lord. 5
One.
is private.
1 to 4. Anybody appearing for respondent number 5? No.
Private as well. I think notice was not issued.
Mr. B. Goswami, the learned additional advocate general, submits that the instant tender which was issued
My lord, yes, tender is
was viable at that relevant point of time,
right.
and what department is
Yes,
this?
it's water.
Water Resource Department, in view of the pendency of the instant writ petition, as well as the order passed on 6/10/2021, whereby the parties were directed to maintain status quo, are reconsidering as to whether the said tender should be gone ahead with. He submits that within a week he can obtain instructions in that regard. Under such circumstances, this court, for the present, issues notice making it returnable on 31st of May 2023, on which day the learned additional advocate general, Mr. B. Goswami, shall obtain the instructions as to whether the government, Water Resource Department, would go ahead with the said tender in question. The issuance of the notice upon the respondent number 5 shall be taken into consideration on the next date. The petitioner is directed to serve extra copies of the writ petition during the course of the day.
All right.
Obliged.
And number 2.
Actually, matter has become infrastructure because matter has become infrastructure. The settlement period is till 36/2020.
Your name?
K. Kolita.
K. Kolita. Heard Mr. K. Kolita, the learned counsel appearing on behalf of the petitioner. Mr. N.K. Devnath appears for the PNRD department. And you?
I am for respondent number 5, Lord.
Your name?
MS Mondal.
MS Mondal appears for the respondent number 5. The learned counsel for the petitioner submits as the settlement period is already over. The instant writ petition has become infructuous. Accordingly, the petition stands closed as it has become infructuous.
Item number 3.
For your lordship, I submit, I would have to point out, your lordship, so far as these petitioners are concerned, 249 in numbers, 244, we have not paid court fee, so far as the rest 243 only.
Yes, tell me, what is your case?
Yes, your lordship, this matter, your lordship, relates to eviction, your lordship. They have come
Eviction
against
under
eviction by the under land revenue regulation, your lordship. Rule
18.
Your lordship, but your lordship, it not specifically says that it is under rule 18. That is, the eviction notices are at page 112. This was the very first, your lordship, in 2000.
What is your claim?
Lordship.
What is your claim?
Claim, your lordship, will kindly come to page 104, Your Lordship. The predecessors in Your Lordship, interest of the present petitioners, Your Lordship, they have way back in the year 1982 filed this petition, Your Lordship.
Yes, then
Then, Your Lordship, what has happened? Thereafter, Your Lordship, some of the petitioners at that particular case was granted settlement of land, Your Lordship. But so far as the rest are concerned, what they did, we don't have any knowledge, Your Lordship. Thereafter, we are occupying and staying there, Your Lordship. And while doing so, Your Lordship, in 2021, first eviction notices were served, and then again it come in the year 2021 itself, Your Lordship, and then we came before this honorable court, and this honorable court passed an interim order, Your Lordship will get it, Your Lordship, by which this honorable court directed the deputy commissioner to pass order, Your Lordship, on our representation and on our claim, Your Lordship. And probably, Your Lordship, that order has been passed and that is produced before this honorable court by the learned government on the when the last matter came up before this honorable court. Copy of the order is there, Your Lordship. It is in vernacular, Your Lordship. We have also filed an IA bringing that order to record, Your Lordship, but that IA is not there, probably. It has not been packed.
so what is your right?
Right, Your Lordship, our case is
Because you, Mr. Bottakar, you have to understand one thing. The judgment which you have shown to me
Lordship. Last part, Your Lordship.
is a judgment of the year 1989.
89.
At that point of time, the reading of Rule 18 was different.
Lordship.
97, the Rule 18 has been amended.
Amended, Your Lordship.
Now, in view of the amendment of Rule 18, you have a right?
Lordship,
18.2.
so far as this order goes, Your Lordship, there is no reference as such to Rule 18. But Your Lordship will kindly.
But Mr. Bottakar, you are well aware. When an authority exercises a power,
No,
whether
Your
they
Lordship.
mention about the provision or not, whether we
No,
are
no.
to only see whether they have the power for that.
No, Your Lordship, not about the authority. What I am saying, submitting, Your Lordship, so far as this judgment stated, Your Lordship, 21/7/89 is concerned. If Your Lordship, may I read, Your Lordship, few lines, Your Lordship. Sri Sen submits that though eviction notices have been issued to the petitioner, their case is covered by the policy decision relating to settlement of agricultural land in the state of Assam by Annex 3, which is a copy of letter number so-and-so, dated so-and-so. From the materials and record, we are not in a position to conclude whether the case of the petitioner is covered by the policy decision referred in the aforesaid annex. All that we would like to state is that if the case of the petitioner are covered by the policy decision as aforesaid, their cases should be considered in the light of policy decision. If, however, their cases were not fall within the ambit of the policy decision, the petitioner shall have to vacate the land under the possession for which such steps would be taken against them is permissible by law. The petitioners would not, however, be evicted till the question of settlement of the land with them as per the policy decision referred to above is decided by the appropriate authority if they are, as on today, possessing the land in question. This was the direction, Your Lordship, and this has, Your Lordship, the basis of, Your Lordship, this direction was that we have certain claims, Your Lordship, on the basis of a policy decision of the government, and they are required to pass some order on this, Your Lordship, either rejecting or allowing, Your Lordship.
What happened?
That is why, Your Lordship, this honorable court passed that direction.
Yes, tell me.
May kindly peruse order dated 15/12/2021 in this case.
Yes.
Submissions of the petitioner as well as of the respondents have duly been recorded here in my lord, and my lord will kindly see, my lord, at page number 2, my lord, the last part, my lord. Petitioner stated that they have submitted representation. My lord, got it, my lord.
Well,
Before the concerned minister of revenue disaster management against the said eviction notices so and paying not to evict them from their place of occupation, and for allotment of land to them serving copy of the same on the circle officer, declares revenue circle on so and so. On the next date fixed, the Deputy Commissioner Sonitpur, the Additional Deputy Commissioner Cycle Officer so-and-so shall apprise the court the reasons for issuance of the impugned eviction notices dated so-and-so. Please this matter and so-and-so. Then, my lord, the interim. In the interim, it is directed that the respondent shall not take any coercive measures against the petitioners in terms of the said eviction notices so-and-so issued by Cycle Officer, Decazoli Revenue Circle, without disposing of the said representation of the petitioner that was received by the Cycle Officer on 3/12/2021. Now, my lord, the Deputy Commissioner has considered all the representations. We have made a tabular format, my lord, and a speaking order has been passed.
Where?
My lord, it has been passed on, my lord, 27th of April 2022. Perhaps this has not been brought on record.
That is not on record, Your Honor.
Where is
This
it?
is, yes, 27th April 2022.
I don't have it. 18/1/2022, there is some order.
Yes, but my lord, it is a detailed report, my lord. This has been, my lord,
Why
addressed.
that is not on record?
No, my lord, because this has been addressed to the Advocate General at a later point of time. Perhaps, my lord, in between this
There
matter
is some
was.
SME's order
Yes.
on 18/1/2022 by the Assam Sarkar Upayukta Karyalayar. This
Yes,
is the Deputy
thereafter-
Commissioner.
Yes, my lord, that was an initial report by the Circle Officer on making.
No. This is given by the Deputy
This is an
Commissioner.
order.
It was by the Deputy Commissioner. Thereafter, a detailed order has been passed
By?
by the Deputy Commissioner, and that order has been intimated, my lord, to the Advocate General. And
Show me.
this bunch of papers, my lord, their representation has been duly adhered to. Everything has been taken on board, my lord. They were given ample opportunity, and the Deputy Commissioner found that most of them are encroaching.
This order, Annexure 10.
It is a
Annexure
part,
10.
it is a, yes, Annexure 10 is there, but Lordship may kindly peruse the first page.
First page is a letter written to the Advocate General.
Yes, my lord, there the instructions have been given, my lord. There, my
Where?
lord will see, my lord. Kindly see the contents of that, my lord, letter. Some of the persons even moved to the Honorable Apex Court also, my lord.
Again, which order?
My lord, against some order, my lord, whereby, my lord, the High Court has not granted them any relief. Perhaps my learned colleague will be in a better position, because that is reflected in the report. Even in the Circle Officer's report, my lord, whereby a detailed field inquiry was conducted, each of the persons, my lord, were asked to submit their relevant testimonials in support of their claims. And one thing which is figured out there, my lord, almost all the persons concerned, they have been found to that they have alternative land. In fact, my lord, other way around, they are not landless persons. And the Circle Officer report,
No, whatever may be, this is the order. Annexure 10.
yes.
But the representation was given to whom? The
Representation,
minister, this, what do you call secretary?
yes,
Revenue and Disaster Management.
yes,
Well,
my
what
lord.
did he do?
No, because the Deputy Commissioner, the eviction notices were issued from the office of the establishment of the Deputy Commissioner. So he is the custodian of the record, he is the authority, Lordship is well aware. Either the circle officer or the Deputy Commissioner has to exercise the power under Rule 80. So therefore, they had taken the call on board. And the circle officer report, my lord, perhaps it should be there. Circle officer's report, I have a extra copy, my lord, here. This is the basis, my lord. Circle officer has conducted a detailed hearing. If my lord allows me to read the vernacular of the circle officer's report, it is just, my lord, 1.5 pages. If I may read it, my lord.
If it comes in the form of an affidavit, your lordship, then it will be helpful for me also to your lordship both.
And the circle officer report, my lord, this is in vernacular. My lord, it says, my lord, it is a report, my lord, by the circle officer to the Deputy Commissioner on 17/1/2022. মহামান্য আদালতত আবেদন কৰা বেদখলকাৰী সকলৰ শুনানিৰ প্ৰতিবেদন উপৰোক্ত বিষয় সন্দৰ্ভত সন্মান সহকাৰে জনাও যে আপোনাৰ নিৰ্দেশক্ৰমে ইংৰাজী 3/1/2022 4/1/2022 আৰু 5/1/2022 তাৰিখে বৰচলা মৌজাৰ গুপ্তেশ্বৰ গাঁও পঞ্চায়ত পৰ্যায়ক্ৰমে আবেদনকাৰী
See, the question before the authorities should be, did you consider their case in terms with the policy decision of the year 1978? That was the only consideration. Did you do that or no? Why we are going beating around the bush with all these other documents that they have able to prove? The direction of the division bench was clear. That at that point of time, the lawyer who was there, the government lawyer, said that there is a policy decision of the year 1978. And in terms with that, the court say that be that as it may, we are not in a position to look into those aspects of the matter as to whether the petitioners would fit in the 1978 policy or get the benefits for that. And as such, gave a handle to the authorities to take a decision. Have you taken a decision on that or
Yes,
not?
yes,
Well,
this is the decision, my lord.
no, this can't be the decision. How can you take the decision or the deputy commissioner can take the decision?
No.
No. The Deputy Commissioner has no power to give allotment, settlement, because the land policy of that was for settlement of agricultural land. So under such circumstances, the Deputy Commissioner couldn't have done that.
Yes, now,
You are only deciding on whether exercise of power under Rule 18 should be made or not. We are not concerned with that. The division bench order was very clear to the effect that you have to do so only after taking into account this.
now, yes, now lordship will kindly consider the present writ petition. Having not done so, the writ petitioners are before my lord, and an order has been passed by this honorable court. Now, in pursuant of this order, my lord, the authorities had undertaken the exercise.
No, the authorities couldn't have done that. Though the Deputy Commissioner couldn't have done that. That exercise, no, the exercise has to be done. You see, the power to exercise under 18 is very much there with the Deputy Commissioner or the circle officer. But that is subject to the power, whether they are entitled to settlement or not in terms with the division bench order.
Lordship will make a clarificatory order, my lord, authorities will immediately move it.
So I'll dispose it of, I'll set aside the notices of eviction and you take whatever is necessary, take a decision or call on that.
My lord will
That day over.
no, my lord will kindly.
No, you thereafter can very well take whatever action you feel like.
Yeah.
I'm not asking, debarring you, but you have to take a decision. Where have you taken a decision till now? The representation, if I'm not wrong, has been submitted to whom?
Representation to the Deputy Commissioner, my lord, and the circle officer.
Where is the representation?
That is your lordship, page 124.
It is given to the minister. That is why I said. Who is the Deputy Commissioner to do all these things? To decide the representation given by the minister? Your power is only to exercise the power under Rule 18. Exercise it after complying with what the division bench has said.
No, even their representation, my lord, they are primarily harping on the eviction notices. That's why, my lord.
Whatever may be,
My lord.
not to do so because of the judgment passed by this, the division bench saying that these are the things that kindly consider. And the division bench had given a clear handle that if they don't fit in, evict them. Why there has been no decision from 1989? And do you want this matter to be further prolonged? You take a decision. Now you have to take a decision as per the new act, new policy. Take a decision as to whether they come within it or not. And thereafter, if you feel like you take whatever action, it didn't fit. Because keeping this matter pending would not help you. You want the land, take it, do whatever it is.
Lordship may kindly be pleased to make some observations with regard to this point, because authorities, my lord, they are just fumbling around. I have to submit this, my lord.
No, your revenue authorities is very good. In fact, what has happened yesterday, yesterday in the second matter,
Yes.
as regards the settlement,
Yes. Come on. Yes.
the person who has drawn the affidavit on behalf of the government, you have to give them all credit for this thing, that the affidavit does not contain what is there in the instructions. The instruction was made a part of the affidavit. The carelessness of the advocate was apparent out there. The reason why they wanted that land in the matter out there was they wanted the land for the purpose of holding having a particular office out there. Why that has not been mentioned in the affidavit? Yesterday, when I was about to sign, I saw it. So all these things I had to make certain changes out here and there.
Yes.
So I gave the liberty for the purpose of, I said that he has no right for the purpose except choosing. You are going to make the demarcation within a particular period. I have not mentioned it.
Yes.
Liberty has been given, you will make the demarcation and give him a compact plot of land of 2 katha 10 lakhs for the time being,
Yes.
till you decide his application,
Yes.
and remaining, and he has no choice as to which part. Because you see, the instruction was clear that he was holding on to the front portion, and thereby the back portion is empty. And your government advocate was silent on that, appearing for the deputy commissioner. Heard Mr. You pay your court fee. Heard Mr. S. Bhattakur, the learned counsel, appearing on behalf of the petitioner. Petitioners. Mr. R. Borpujari appears on behalf of the respondent number 1, Mr. N. Goswami appears for the respondent number 2, 3, and 4.
My lord.
The petition is taken up for disposal at the motion stage, taking into account the various orders which have been passed and the records being made available during the course of the hearing. The petitioner herein claims that they are in possession of certain government lands. The claims that their predecessor in interest have been in possession of certain government lands.
Lordship may kindly mention.
There were various eviction proceedings initiated against the predecessor in interest of the petitioners, for which a challenge was made before this court in civil rule number 867/1982. It appears from record that the division bench of this court, by the judgment and order dated 21/7/1989, disposed of the said writ petition. While disposing of the said writ petition, the division bench took into account the submissions so made by the learned counsel appearing on behalf of the predecessors of the petitioners in the said writ petition, to the effect that though the eviction notices have been issued to the petitioners, their case is covered by the policy decision relating to settlement of agricultural land in the state of Assam, which was made a part of the said writ petition as Annexure 3. The division bench, taking into account that as to whether the petitioners in the said writ petition would come within the ambit of the said policy decision of the government of Assam, gave the liberty to the respondents to take a decision as regards the question of settlement of the petitioners in pursuance to the said policy decision. It was further made clear if the cases of the petitioners did not fall within the ambit of the policy decision, the petitioners shall have to vacate the land under their possession, for which such steps would be taken against them as is permissible under law. It was further made clear that till a decision is taken by the authorities relating to the question of settlement on the basis of the policy decision, the possession of the petitioners therein should not be affected. Paragraph number 2 of the said judgment is reproduced herein under page 105. It is the case of the petitioners in the present writ petition that pursuant to the decision rendered by the division bench, some of the petitioners in the said writ petition, that is civil rule number so and so 8867/1982, were granted settlement or allotment. However, in respect to the other petitioners, whose successor in interest are the present petitioners, there was no information from the respondent authorities, and the petitioners herein continued to reside over their lands in their possession. It further appears on records that the circle officer, Dhekiajuli Revenue Circle, on 15/11/2021 issued various notices directing the petitioners to vacate the encroached land within 15/12/2021. The petitioners thereupon conjointly submitted a representation before the Minister, Revenue and Disaster Management Department, Government of Assam, which was duly received through the Circle Officer, Dhekiyajuli Revenue Circle, which was duly received on 3/12/2021 by the Office of the Circle Officer, Dhekiyajuli Revenue Circle. A perusal of the said representation shows that the claim of the petitioner is on the basis of the order judgment dated 21/7/1989 in Civil Rule number 867/1982. In paragraph number 9 of the said representation, it was the categorical case of the petitioners herein that the government had allotted lands to families of some of the petitioners in Civil Rule number 867/1982, as well as Civil Appeal number 509/1983. However, the government had not allotted the land to the families of the petitioners, including the parents, their parents and their families. It was also mentioned that the petitioners' parents and families were also before this court as well as the Supreme Court. And therefore, it was the prayer of the petitioners herein in the said representation that they should also be granted allotment or settlement as have been done in other similar, as has been given to other similarly situated persons, pursuant to the judgment dated so and so in Civil Rule number 867/1982. It appears thereupon that the petitioners filed the instant writ petition on 10th of December 2021. When the instant writ petition was listed, this court, by an order dated 15/12/2021, after recording the submissions of the petitioner, in the interim, directed that the respondent shall not take any coercive measures against the petitioners in terms with the eviction notices dated 15/11/2021 issued by the Circle Officer, Dhekiyajuli Revenue Circle, without disposing of the said representation of the petitioners that was received by the Circle Officer, Dhekiyajuli Revenue Circle, Dhekiyajuli, on 3/12/2021. It further appears that this court, by the order dated 15/12/2021, again fixed the matter on 2/2/2022. Thereupon, the interim order was extended and the writ petition was directed to be listed after 2 weeks. However, the matter has been listed today before this court. The learned counsel appearing on behalf of the petitioner submitted that in view of the order, judgment dated so-and-so in the civil appeal, civil rule number 867/1989, the petitioners herein, who are the successor in interest of the petitioners in civil rule number so-and-so, cannot be evicted without compliance to the directions so passed in the said judgment dated so-and-so as to whether the predecessors of the petitioner or the petitioners would be entitled to settlement / allotment in terms with the policy decision dated of the year 1978. The learned counsel for the petitioner further submitted that the respondent authorities, though had granted some allotment or settlement in respect of others, some of the petitioners in civil rule number so-and-so, but did not pass any orders in favor of the predecessor in interest of the petitioners or the petitioners herein. However, the petitioners continued to reside, and the respondent authorities also allowed the petitioners to reside since 1989 till 2021. It was only on 15/11/2021 that individual notices were issued to the petitioners, asking them to vacate within 1 month. It is under such circumstances that the petitioners have submitted a conjoint representation before the Minister of Revenue and Disaster Management, which is still through the circle officer, which is still pending. It is therefore the submission of the learned counsel for the petitioner that the issuance of the impugned notices are in violation to the orders passed by the division bench dated so-and-so, order and judgment passed by the division bench dated so-and-so in civil rule number so-and-so. And as such impugned notices are nullity in the eyes of law. On the other hand, Mr. Arbor Puzadi, the learned counsel appearing on behalf, anything else? On the other hand, Mr. Arbor Puzadi, the learned counsel appearing on behalf of the Revenue and Disaster Management Department, submitted that pursuant to the representation so submitted on 3/12/2021, a detailed inquiry proceedings was conducted by the Deputy Commissioner, by the Office of the Circle Officer, as well as the Casualty Revenue Circle, as well as the Deputy Commissioner. And in pursuance thereto, An order was passed on 18/1/2022.
The last paragraph, যিহেতু মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ত দাখিল কৰা আবেদনকাৰীসকলৰ কিছু লোকে তেওঁলোকৰ সমৰ্থনত সম্পূৰ্ণ তথ্য দাখিল কৰিব পৰা নাই, আকৌ যিহেতু কিছু লোকৰ হাতত কোনো নথি পত্ৰ নাই আৰু যিহেতু বেদখলকাৰী, সেয়েহে তেখেতসকলে আবেদন কৰা মতে উচ্ছেদ কৰিব বিচৰা মাটি দাবীদাৰ হোৱাটো গ্ৰহণযোগ্য নহয়. So they are not entitled for allotment. Precisely, it has not been happily worded in terms of the judgment passed by the Honorable Court. Perhaps the authorities have
Have they
mistake.
taken into account the 78 land policy?
70 land policy appears to have been not, but it is not mentioned here precisely whether 19.
What did they take into account?
Perhaps 2019 land policy.
If he had instead passed an order which was similar to the instructions which was given to your Advocate General, it would have been better. Don't you think so?
Because
That is why I'm not bringing that.
my lord,
You use that.
yes, my lord.
That is more happily worded than this.
This is the difficulty, my lord.
No, but he has the difficulty in passing an order in a proper manner, but he has no difficulty in giving instructions to the Advocate General in a more detailed manner. The vernacular version of the said order dated 18/1/2022 was placed before this court. Where is this land?
It is within Hestiazuli Revenue Circle.
Where?
By the side of Brahmaputra.
Huh?
Village called Bothasimolo.
Village Bothasimolo. My lord,
It's in village.
yes, village. Almost, my lord, shore area. It is in the banks of Brahmaputra. Because more often, my lord, my lord, incidents of alluvian and diluvian takes place. So therefore, they shift. That is the difficulty, my lord. In some areas, authorities are unable to even survey and demarcate.
From a perusal of the order dated 18/1/2022, it does not transpire that the Deputy Commissioner Punitpur have passed the order in the manner stated in the judgment dated so and so in civil rule number so and so. The direction passed by the division bench in its judgment dated so and so was clear and unambiguous to consider as to whether the petitioners therein would be entitled to claims allotment or settlement in terms with the land policy of 1978. It can be seen from the instructions which was placed by Mr. Arbor Pujari that only petitioner numbers, there were 5 petitioners in your instructions you see in the first page.
Yes, my lord.
5 petitioner, petition number 47 down below. Yes. Those 5 petitioners. No, there, down below the last paragraph.
Yes, my lord. Out of 74, four numbers of petitioners.
Ah,
4 numbers of petitioners. Lordship,
yes,
yes.
give it. Petitioner numbers.
Yes. Petitioner is number 5, petitioner number 184, 185, and 212.
212 would not show their linkage with the petitioners in civil rule number so and so.
So, my lord, I'm sorry. It will be 5, my lord, because four have shown it. My lord, I am corrected, my lord. It will be petitioner number 51, my lord, then 241, 216, 145, and 224.
Have not been able to show their linkage with the petitioners in civil rule number so and so. But the question which ought to have been decided by the authorities concerned as to whether the petitioners herein would be entitled to in terms with the land policy of 1978. However, the actions so taken by issuing the impugned notices on 15/11/2021. Now, be that as it may, it is relevant to take note of that as on the date of issuance of the impugned notices, there was no compliance to the order passed by the division bench in so and so, in a judgment of the division bench in civil rule number so and so. And therefore, the said impugned notices being in contravention of the order passed by this court, by the division bench of this court, is therefore a nullity. And accordingly, the said impugned notices are set aside and quashed. As regards the order dated 18/1/2022, though there has been no challenge to the same, as the same was passed after the filing of the instant writ petition. But the said order dated 18/1/2022 do not address in terms with the requirement of the order judgment dated so and so passed in civil rule number so and so. Accordingly, the instant writ petition stands therefore disposed of with the following observations and directions. Number one, the impugned notices so issued dated 15/11/2021 against the petitioners enclosed as annexure
And it's a your lordship F series.
Hmm?
F series.
F series are interfered with and are interfered with and accordingly set aside and quashed. Number two, the order dated 18/1/2022 is not in consonance with the order passed by the division bench or judgment passed by the division bench dated so and so in civil rule number so and so. Number three, this court grants the liberty to the state respondent authorities to take a fresh decision on the representation so submitted, taking into account further materials if so required after the initial inquiry which was done, and to decide whether the petitioners fall within the ambit of the policy decision of the government of Assam for allotment, public settlement of land, in terms with settlement, in terms with the policy decision recorded in the letter number RSS.96/71/25 dated 29/11/1978, or such policy decision presently prevalent. It is made next. It is made clear that till a decision is not taken by the respondent authorities in terms with the directions as given in clause 3 herein above, the respondent authorities shall not take any action of eviction against the petitions.
While disposing the representation, you may be given a tip. You may be personally hurt.
You have already heard. What else do you have? Inquiry has already been done. Let them take a decision. They have all the materials. That is why I am not giving them. And yes, within some time.
Yes, sometime, my lord, and pursuant to such decision being taken, to be taken by the authorities, some liberty, my lord, to proceed against the persons in accordance with law, my lord. Because once this decision is taken, my lord, some handle the consequence, my lord.
Shall not be evicted without taking a decision. It is, however, clarified that upon the decision so taken, in terms of what has been mentioned in clause 3, Roman 3 herein above, the authorities shall be at liberty to take such action as deemed fit in accordance with.
I'm so
Deeply
obliged,
obliged.
my lord.
Mr. Bhattakur, Mr. Bhattakur, the learned counsel appearing on behalf of the petitioner, undertakes to pay the deficit court fee within 7 days.
Of life. Item number 4 to
23 for admission.
Yes. What happened? Yes, you have filed some reply. What is that?
Yes, we have filed. I think it has been brought.
On the last occasion, they had filed some affidavit.
Yes.
One affidavit couldn't put. Where have you filed that affidavit?
I filed in my lord 3817 2020. Onima Deka.
item number 11. Item number 11.
And what is your reply? What is your send in the reply? Some reply filed on 24 2023 is that reply, no? Yes, what is there in this reply?
This is our reply to government additional affidavit dated 10/5/23. Government has filed two affidavits.
Filed by respondent number 3.
Yes, madam.
Government's first affidavit is 22/3/23. Then our reply to government is on 19/4/23. And then government reply again. Description. Detailed affidavit on 10/5/23. And our reply is of 22/5/23.
Yes. What is there in the reply?
Let them complete their argument, because they didn't reply. He has not completed.
Yes, tell me.
But on last occasion, my lord, I have filed the affidavit, my lord, stating that the list was published in the official website.
That you have
Seeking
taken.
clarification from the concerned person if there is any rectification or modification is required. That was my stand regarding the publication of the list in the website. My lord. So as regards the, my lord, regarding the provision of section 4.2.4.1, my lord. So I would like to again rely upon the section 10.4, my lord. The requirement of section 10.4. In earlier occasion also, my lord, I put my argument was based on that there is a requirement to issue the notification under section 10.4. Then only, my lord,
Who will issue the notification?
state government, my lord.
State government in the name of?
Name of governor, my lord. In fact, I don't have that notification issued in terms of the 2011 Act, my lord. But in case of
Who will
2007,
issue that notification?
here, my lord, the director who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their services provincialized. So it is the state government who will issue the notification, my lord. Director shall forward the list to the government, then government will issue the notification, my lord, under section 10.4.
Can a notification be issued by the state government? Or is it in the name of the governor?
It is in the name of the governor, my lord.
So it will be done under 166.2.
Yes, my lord.
Now, if it is done under 166.2, would such notification have any publication made in the website would have any consequence?
In the website, my lord, we just publish the list, my lord, not the notification.
No, there is no notification.
There was no notification. In fact, the requirement of notification is further fortified from the section 6 also, my lord. Section 6 of the Act. Page 656, my lord.
56.
656.
Yes.
Superintendence and control of the educational institutions where services of employees are provincialized will affect from the
superintendence and control of all education.
with effect from the date of publication of the notification under subsection 4 of section 10, the superintendence and control of all educational institutions coming within the purview of this Act shall vest in the state government. Until and unless, my lord, that notification is not been published, my lord.
So are you saying that the difference between the new Act and the old Act?
Yes.
Once the notification comes under 10.4, as per the old Act, the provincialization takes effect from the date of the coming into force of the Act.
Yes, ma'am.
Whereas as per the new Act, the provincialization comes into force from the date of the notice.
Yes, ma'am.
So section 3, if we look into it, says that they will be considered for eligibility.
Eligibility.
And 4 says it is only the eligible institutions where it will.
Yes, ma'am.
And eligibility is in respect of 10.
10.
So without that notification, the question of the section 4 coming into play does not arise.
Yes, ma'am.
That's your subject.
Yes. In fact, which is further fortified from this section 6 also, my lord. Because once it is provincialized, then only, my lord, it will come under the state government, my lord. The education
So once
institution.
that notification
Yes.
is there, then only.
Then only. In fact,
Have you looked into their affidavit in yesterday filed or something, they say something about?
Yes, yes, yes. In fact, my lord, I have received today morning, my lord, though they have served in the office, my lord.
Hmm.
In the morning, I have received the affidavit.
And how do you distinguish the judgment of Justice Buzurgurwa?
Yes, my lord. In fact, my lord, this issue has been in another case, my lord. In case of Purnavati Brahma,
Hmm.
this issue went to the division bench, my lord.
Hmm.
In fact, in the division bench, one of the honorable judge is Mr. Honorable Justice M. Buzurgurwa also, my lord. So here, my lord, this issue has been dealt with, my lord. Whether, my lord, can mandamus issued, my lord, under the repeal act, my lord?
Huh?
Can be a mandamus issued under the repeal act, my lord. That issue has been dealt with, my lord.
Oh,
Here in this retail, my lord.
So this is pursuant thereto.
Yes, my lord. This order date of judgment is 13/11/2019, and the earlier decision is, I think, in 2018, my lord.
You need not go into the other Yes, what is this?
Paragraph 9 of this, in fact, my lord, in this order, my lord, the review order in the case of Chandan Kumar Neog has been discussed.
What is this Chandan Kumar Neog?
Chandan Kumar Neog is the, my lord, whereby the act was struck down.
Oh, that one.
That one. Thereafter, my lord, in Bimol Kutum, the state has filed a review in Bimol Kutum case, my lord, and that review order has been discussed, paragraph 7 and paragraph 8 of this judgment, my lord. Finally, at paragraph 9.
What happened to the review? It was dismissed. Review has been dismissed.
No, in review,
Court decided
state has
on the following
been given the liberty to
the state in its own, in their application of the group, they are concerned with our those who have retired and are joining.
Page 27. It is part of your document. Page 27. Exactly.
So this says, as per the review judgment, it says that we are not doing anything, but let the legislature do it.
Yes, my lord.
And the legislature
That
brought
way,
in
my lord,
20.
24,
Then what happened?
paragraph 9, my lord.
Yeah.
The case as projected by the learned counsel for appellant to the effect that the appellant was vested right under the Act of 2011 on the date when judgment was rendered in Chandan Kumar Neog Supra cannot be accepted. The very fact that the service of the petitioner had not been provincialized and therefore the writ petition was filed makes it clear that the case of the petitioner would not be covered by the four corners of the decision rendered on the review petition. Admittedly, the petitioner was not getting salary as provincialized employee. Therefore, it would be a fallacy in law and facts to consider that the right had already been vested in the petitioner under the Act of 2011, which admittedly has been struck down as constitutionally invalid. The review court has held that the doctrine of prospective overruling would not apply as the said power is vested only with the Supreme Court of India. It is in such circumstances, it has been provided in paragraph 4 of the judgment rendered
Para
by,
19.
para 19 of judgment rendered by the review court that the right of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so decides. Till then, it is ordered that the service of the provincialist category and their status as government employee shall not be disturbed, and they will continue to receive all the benefits which they are getting under Provincialization Act 2011 since struck down by the judgment under review. Then, my lord, under paragraph 10, my lord, liberty was given under section 70 to consider
read
it. We are conscious of the fact that subsequently the Assam Educational Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017 was brought in place with effect from 11th April 2017. In the impugn order passed by the learned single judge, it has been said that no writ of mandamus can be issued in view of the fact that the Act of 2011 is not in force. However, liberty was given to the writ petitioner to approach appropriate educational tribunal for consideration of our case for provincialization as per law in force. The respondents from the Education Department were also asked to consider the case of the writ petitioner for provincialization under the Act of 2017, if she is entitled to the same in terms of the provision of the Act of 2017. Since the Act of 2011 was held unconstitutionally invalid, as noted above, we find no reason to differ with the view taken by the learned single judge.
So you mean to say that in view of this judgment,
Yes, ma'am.
this court cannot issue the prayer, the relief which the petitioner.
Yes, ma'am. They are also
They
praying for a
were
relief.
not getting salary.
Yes, ma'am. They are also praying for a relief under the struck down act, my lord. And here also the Honorable Division Bench has held that under the struck down act, they are not entitled for any relief.
No, can't you say that they come within the ambit of that their relief has already crystallized by section 4? And they are only asking the entitlement on the basis of their crystallized right.
In that regard, I will say, my lord, in a struck down act,
I am only going to give them the benefits of that, the entitlement out of the crystallized right.
in fact, in respect of an act struck down by this honorable court or declared as constitutionally invalid, no right can be accrued, my lord, under any circumstances.
No, if the right has by deeming statute has already accrued.
But that act has been struck down by the.
Unless, therefore, again it boils then to 10-4.
Yes, my lord.
If the right has already accrued, just for example, a person as per a particular act, I am entitled to certain amounts.
Yes.
I am entitled. After that, the act is repealed. But does my entitlement go?
But act of repealing and struck down by honor.
Yes, one thing. My eligibility is a different thing.
Yes, my lord.
No, act is repealed. Let us assume the act has been repealed.
Yes, my lord.
Then also, would it say that all rights which has accrued has been ended? Can you say that? And more so when 24 comes in. Yes, that is why last time I put that particular question to you.
24, we have to apply considering the eligibility criteria.
Yes, you can still apply.
Yes, my lord.
Now, once you applied, you found that no, these schools do not meet it. You can very well take a decision that we are not going to go to give them. But if a right has already accrued upon them at that point of time, would they not be entitled on the benefit of that?
But here I am differing, my lord, because right has not been accrued because 10 for requirement of 10 for.
All again comes back to 10 for.
Service records of eligible teaching and non-teaching staff of a venture educational institution for the purpose of provincialization. Section 10 provides for 3 levels of scrutiny. At the initial stage, scrutiny by the district scrutiny committee, constituted by the deputy commissioner of the district. After scrutiny at this level is over, the verified list is to be forwarded to the concerned director, who at his level shall make further scrutiny if required. Therefore, scrutiny by the director is the intermediate level scrutiny. After this round is over, he shall forward the verified list as scrutinized by him to the concerned department of the state government for final consideration and for issuance of provincialization notification. Thus, until and unless the verification process is completed at the level of state government, consequent upon which provincialization notification is issued, the rival claims to provincialization would remain within the realm of verification without any finality attached. At the interim stage of verification, be at the level of district scrutiny committee or at the level of director, nothing is finalized. Consequently, no right is created in favor of anybody. If no right is created, question of enforcement of any right and corresponding infringement of any right of any other person would not arise. Therefore, a writ petition filed in the midst of the verification process under Section 10 of the Provincialization Act would be premature. Having regard to the discussions made above, this court finds no merit in the writ petition, which accordingly dismissed. Interim order passed on 27/5/2013 stands vacated.
What
However,
is this Abdul Ghaffur Mandal case?
that is by that manner, the education tribunal was constituted. Manner.
What does it say?
For constitution of educational tribunal for rival claim of teaching and non-teaching staff of Hansard Education Institution. For that, in the district level, last line, however, it is made clear that upon issuance of the provincialization notification, if any person is aggrieved by some, the aggrieved person may avail the appropriate remedy in terms of full bench judgment of this court in the Abdul.
Oh, it is untimed. If he is aggrieved by anything, then he goes to the education tribe.
Yes, in page 1 of the education manual, the notification is there for constitution of.
So therefore, I ask you, what is the why the notification is required?
Notification under section 10(4).
So without there being a compliance in terms with Article 166(2), whether merely by giving or uploading something, would that amount to a compliance?
Yes. Yes. In fact, my lord, what I'm saying, my lord, without issuing the notification, we cannot comply with the section 6, my lord. Because once it is provincialized, then only, my lord, government takes the control over the institution. So section 6 clearly states that, my lord, the notification is required.
But therefore, the difference between the two acts is that once, although section 4 says from the date of the notification in respect in 2017, but in this case, it is deemed. Once it is eligible.
Yes. From date of deemed, from the date of
coming into force.
Coming into force, the act, my lord.
So you mean
but
to
for
say
that purpose,
once it is eligible, then only they will be deemed.
Yes, ma'am.
Was this judgment of Justice Bhuiya taken by Justice Buzar-Burwa?
No, my lord.
Let's see Justice Buzar-Burwa judgment.
Yes,
what has been relied upon, taking into account that you have already implemented it.
For that, you can rely on the judgment.
3/10/2018.
Yes, my lord. On last occasion, my lord was pleased to that judgment phase.
There are two judgments.
87. Page 87.
Polima Poro, it is 94 and
In Nirupoma,
Nirupoma Baro,
here, my lord, 87, my lord, page 87. No, it is 18, 20.
page 90, you come,
Yes, my lord.
the third line.
Provision of section 10(4) is merely for providing a procedure to be followed by the authorities, arriving at its conclusion as to whether the given employee is within the permissible number as provided in the schedule. In the event the authorities, pursuant to the such process, arrived at a conclusion that the concerned employee is within the permissible number as provided in the schedule, there is no further requirement of issuing any administrative order for provincializing the service of the concerned employee in as much as his service already stood provincialization by operation of law under section 4(1) of the Act of 2011. Any such order that the authorities may pass would be only in the nature of an order recognizing the provincialization of the concerned employee, which has already taken place by operation of law, and such order of recognition cannot be constituted to be an order provincializing his service.
So you have taken note of 10.4. Have not taken into account that it is a notification.
Yes.
Now, can this court, in view of the above, differ with it?
Paragraph 14.
Now, if I hold it, there are notification is required. Wouldn't this court would be going against the order being passed by a court named?
But here the 6, section 6 has not been taken note of.
All along you have been saying 10.4, now you are saying 6.
Because 6 provides that to have the control over the higher education institutions, there is a requirement of issuing notification under 10.4. So that aspect has not been gone into it.
Again, it says paragraph 15, it is clarified that this order has been passed upon an interpretation of the provision of section 4.1 read with 10.4 of the Act and has been passed only upon the circumstances that the prior to Iman being declared when the authorities have already arrived at the conclusion that the petitioner is included within the number of posts under the schedule and therefore it being so, his service to provincialize by operation of law. It is also provided that even the government has accorded their approval to the aspect that petitioner came within the number of posts provided in the schedule before the act was declared approved. The provisions of this order be not construed to provide that the provincialization can still go on, even in absence of a situation based on which this order, with the above the petitions, can allow that the petitioners be provided. Now, what happens to the next order?
Here, in Dilip Das case, there's a stay order by this
Soham
honorable
Islam,
court.
Tohidur Islam. We have just quoted.
Yes, my lord. In Dilip Das case, there was a stay order. And during the intervening period, the other employees, that institution, their services have been provincialized.
Now tell me, how do I differ? You have already taken note of 10.4. And has come to a finding, an interpretation that in view of 4.1, once it is the act comes to it and it being an eligible institution. Now, if I have to differ out here, how do I differ?
Section 6, madam. Because in Dilip Das case, madam, this is a case of individual. Here is a case of an institution.
Section 6 is vesting of the school.
Exactly, madam.
To the government.
Exactly, madam. Here, madam, there is a case of school, madam. Though, madam, they are filing in individual capacity, madam. Here, Nirupoma and 4 others, all are from same school, madam. But in Dilip Das case, madam, the particular college that has already been provincialized, but the post held by the Dilip Das was due to stay order from this honorable court, madam. It was held up, madam. Subsequently,
are you saying that the facts are different?
Yes, madam.
On the ground that it was given in the case where the school was already provincial.
Yes, madam.
How do you find the fact out here?
Because, madam, this Dilip Das, I have relied on the Torunnath case, madam. Torunnath was the person, he initially filed the case against Dilip Das, madam.
Torunnath is where? Oh, that one.
Yes, madam.
This is where?
This is where, madam. Kindly see the area of parties, madam.
Huh?
Area of parties.
Ah.
Torunnath. Then, madam, response number 5 is Dilip Das.
But how do you say that the school has been provincialized? Because once the school is provincialized, by dint of section 4, they will come in. Where do I get the fact what you are saying?
Para 3 of this, page 3 of the Torunnath judgment, madam.
Yes.
It is admitted that college authority had forwarded the name of Responsible Justice. Responsible 5 as per seniority. The government provincialized the commerce stream of college and as per seniority is provincialized the service of 3 grade 4 staff, including
where is
page 3, bottom 5 lines, madam.
It is admitted that the college authority has forwarded the name of the son as per the government provincialized the commerce stream of the college and as per the seniority provincialized the service of 3 grade 4. Out the others in the would have stated that an advertisement. Now, Dilip Das comes within Respondent number 5 was there, na?
Yeah, yes, my lord. He is Dilip Das, my lord.
In his affidavit has stated that advertisement was put on so and so by the cottage for Now kindly come to page 5, the second paragraph, last 3 lines.
Therefore, the college had forwarded the name of
No. Second paragraph. That is, judgment has no paragraph, that is the problem. Last paragraph before that. From the materials on record, it's not discernible as to whether the additional commercial stream of the college has been provincialized or not, and as such, no order has been placed before this court. Anything else?
as regards my lord,
So your two judgment is one is Tovundas and the other is the division bench.
yes, my lord. And regarding my lord, issuance of mandamus under a struck down act, my lord, I'm relying on this the Surya Kumar Opram, my lord. State of Manipur versus Surya Kumar Opram. (2022) SCC online SC 130.
Yes, where
But here, my lord, I am relying paragraph 18, 19, then my lord 22, 23, 24, and finally, my lord 28 and 29.
18, 19 is somebody,
Yes, my lord. Quoted, my lord.
I take the effect of repeating a separate to be a repeat. What does the Supreme Court?
And 22, my lord, where a statute is adjudged to be unconstitutional, it is as if it had never been. Right cannot be built up under it. Contracts which depend upon it for their consideration are void. It constitutes a protection to no one who had acted under it, and no one can be punished for having refused obedience to it before the decision made. Will so and so observe that an unconstitutional act is not law. It confers no right. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. An unconstitutional law, be it either due to lack of legislative competence or in violation of fundamental rights guaranteed under Part 3 of the Constitution of India, is void ab initio. In so-and-so versus so-and-so, it was held by a constitutional bench of this court that lawmaking power of state is restricted by written fundamental law, and any law enacted and opposed to the fundamental law is in excess of the legislative authority and is thus a nullity. A declaration of unconstitutionality brought about by lack of legislative power, as well as declaration of unconstitutionality brought about by reason of abridgment of fundamental rights, goes to the root of power itself, making the law void in its inception. Then, my lord, paragraph 24, my lord. The power of legislative body to repeal a law is coextensive with its power to enact a law. The effect of repealing of a statute is to obliterate it completely from the record of Parliament. While repealing a statute, the legislature is competent to introduce a clause saving any right, privilege, liability, penalty, act, or deed duly done, and any investigation, legal proceeding, or remedy arising therefrom under the repeal statute. There is a distinction between declaration of a statute as unconstitutional by a court of law and the repeal of a statute by legislature. On declaration of a statute as unconstitutional, it becomes void ab initio. Saving past transactions are within the exclusive domain of the court. On the other hand, though the consequences of repeal is also obliteration of the statute with retrospective effect on the past transaction, the legislature is empowered to introduce a saving clause in the repealing act. Even in case where saving clause is not made, the provision of the General Clauses Act are applicable to central statutes, and the principle of General Clauses Act can be applicable to the statute made by the state legislature as well. It is relevant to state at this point that Manipur legislature enacted the Manipur General Clauses Act 1966, which came into force 33/1966, by which the provision of General Clause Act 1897 were made applicable to the statutes of the Manipur legislation. So finally, my lord, paragraph 28, the principle has been laid down, my lord. The principles that can be deduced from the law laid down by this court as referred to above are: a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. After declaration of a statute as unconstitutional by a court of law, it is known as for all purpose. In declaration of the law, the doctrine of prospective overruling can be applied by this court to save past transaction under earlier decisions superseded or statute held unconstitutional. Relief can be molded by this court in excess of its powers under Article 142 of the Constitution of India, notwithstanding the declaration of the statute as unconstitutional. Therefore, it is clear that there is no question of repeal of a statute which has been declared as unconstitutional by a court. The very declaration by a court that a statute is unconstitutional obliterates the statute entirely as though it had never been passed. The consequences of declaration of unconstitutionality of a statute have to be dealt with only by the court. So here also, my lord, this 2011 Act has been declared as unconstitutional by this honorable court, my lord. So that means, my lord, it is known as, it is void of initio, my lord. So no relief can be, granted.
So unless saved.
Unless saved, my lord.
The saving has been done under 24.
Yes, my lord. That to liberty given by the in review petition.
Saving has been done under 24. The review petition did not say anything. Say that
Yes,
the
my lord.
power of prospective overruling we can't do it.
Yes, my lord.
It is for the Supreme Court who can. So under such circumstances, we are not saying anything, but the legislature can very well enact.
Yes, my lord.
But those persons who have been enjoying any rights out there shall continue
That is
to
why,
see such decisions.
Yes, my lord. Who have already acquired the right, who have enjoyed the to save their my lord, service or pension in case of retirement. That is why that clause has been added, my lord. But in respect to the petitioner, my lord, they have no right has been accrued in favor of them, my lord, under the 2011 Act. They are not getting the benefit. In fact, in the division bench judgment, it has been clearly reflected on they are not, their service has not been provincialized, and they are not getting any salary, my lord. That aspect has been dealt with the Padmavati Brahmo case, my lord. Paragraph 9.
This is after the judgment.
After this Dilip Das judgment, my lord.
Dilip Das was not taken into consideration.
Yes, my lord.
Anything else?
No.
Yes, Mr. Gupta.
May I please?
Obliged.
As I understand the case, I'll try to keep it very simple. There was a 2011 Act. It provincialized the venture. A long-standing demand was met. Between 2011 and the judgment of this court, 23/9/16, several things have taken. That is the first thing. Then from 16 to the state government's review, which came in 2017. 2117. That is the second. Then comes the 2000 Act, which is the third thing. Now, certain things were done during this long period of 2011 to 2016. What was done is they have provincialized a huge number of venture schools and other educational institutions. They have provincialized over 40,000 teachers' posts. How was it done? By following the same procedure which your lordship has seen in this case. 3-layer scrutiny contemplated under section 10. The scrutinizing committee, the forward director scrutinize, the forward, etc. And then the government through its website notify. These are the eligible schools. These are the eligible teachers as per the 2011 Act, read with that schedule. Get completed. The process is over. People, institutions are provincialized. Notified teachers are provincialized. They don't get the pay. Some are getting, some are not getting. We belong to that group who didn't get. That's why we are before your lordship.
Mr. Goswami, has anybody got it without a notification
This
and
is the
without a
notification.
court's order? No, without a court's order. Has anybody got?
Oh, yes. I'll show from their review judgment their own arguments. 40,000 people we have done. Protect them. That's the plea before the division bench in review.
No, my question is whether without a notification
It is the
under
same
10.4,
It's same procedure.
they have given the benefit to others without a court's order.
Yes. It's their case in the review. 40,000 people we have already employed, provincialized. How? This is the same procedure. The same procedure was followed. It is mentioned in the review order. That is why the state is filing a review, that it will create chaos. Protect them. The press release which you have annexed with this last, your lordships can see that. Last affidavit we filed with it. Last one. Page 159 is the press release. It is 2014, 10th of July. CM approves provincialization of 4,865 posts. This school, July 10, Chief Minister Tarun Gogoi today approved the provincialization of 4,865 posts in 461 high and higher secondary schools under Assam Venture Educational Institution Provincialization of Service Act. This is in addition to the 41,454 posts already provincialized in 2011 and 12 and 2012 and 13. And if your lordship sees at the review order, the number which the learned counsel for the state mentioned, that we have a problem of 41,634 provincialized teachers.
Where is the review order?
Yes, that is your lordship. And that,
Oh, this one. Page 33.
only Onima data I was placing before your lordship. If your lordship is having that,
I've got it.
and that is at review order is at page 27. Longish order, I don't have to cover. Only for this purpose, why the state has filed this. Page 48. Starts at the bottom of page 47, paragraph 8. Each learned additional advocate general submits that if the judgment is applied retrospectively from the date of inception of the Provincialization Act, it will impact nearly 41,634 provincialized teachers and staff. Moreover, if the act is to be treated as invalid since inception, all the benefits which have accrued to the beneficiary will have to be recovered and the status of the provincialized category will run into private employees. The impact of those beneficiaries who have already superannuated from service will be harsh as their pension payment will have to be stopped. Similarly, wages for provincialized staff cannot be paid from the government coffer, and the question of recovery of the already paid sum may have to be considered. So it was a very difficult situation for the government under which they have filed this review, my lord, after the judgment. And court takes note of this, which your lordship has find at page 53. Page 53. There are around 41,634 employees for whom vested rights are already created under the 11 enactment, but through retrospective application of our 23rd September judgment, they may not lose their government job, but will also be disentitled to pension and salary. Moreover, the question of recovery of the already disbursed salary may emerge. The harsh impact of the retrospective application will be crippling for the already provincialized group and their livelihood, and in turn life itself will be adversely affected. All such debilitating consequences will occur without any opportunity of hearing to this category. Many families dependent on their earnings and provincialized staff are enjoying a measure of social and economic scrutiny, and they all will be thrown out to the streets without any fault of theirs. In the above circumstances, we are of the considered view that the rights of the employees who have been benefited under the struck-down statute can be taken care of by giving retrospective effect to the proposed legislation. If the legislature so decides, till then, it is ordered that the services of the provincialized category and their status as government employees shall not be disturbed, and they will continue to receive all the benefits which they are getting under the Provincialization Act. So first judgment in 16, this judgment comes in 17, they protect till the legislation comes. Whatever has been done under the 2011 Act, it is protected by the division. Because the state is also saying that we are before you because this is a huge human problem which will be created. If those who are already provincialized or whose rights have accrued under this Act, if it vanishes into thin air because of the High Court judgment. So court took into account all this, and even after holding about prospective overruling and all that, in substance, the government was asking for a relief that their rights should not be disturbed. Court says, you are going to make a law, you have said, go make a law. Till then, we protect. That's the position. So it will be inconsistent if today the state government tries to say that no right accrued. They were filing a review petition. They told the court in the first instance that scrap this act. Court expresses surprise, but
No, but the state is not saying that the right does not accrue. The state is saying that without a notification on the 10-4, no notification.
I will come immediately. But
Otherwise, once the right is accrued on the
right,
basis of a
then
notification.
we'll see how this.
Only thing, Mr. Goswami, my specific query to you was, has the government, in absence of a court order, now in Dilip Das there is a court order, that you give them the benefit without a divorce or notification. Has the government given any benefits under the 2011 Act to those persons during that period when the Act was in existence without a notification? Then it will be a case of pick and choose.
To the state government.
Huh?
Don't put that question to me. Kindly put that question to the state government. Let them say. I have told what they have said before the division bench. That 40,000 people who have provincialized, it will create complications for them. If they want to say that this is not the only procedure we have followed, but additionally we have done this, then only right accrues, I can understand that.
Yes.
They are not saying that.
No, without notification, this 41,000, they are not appointed without notification, my lord. No, provincialized. They have been provincialized with the 10-4 notification, my lord.
Correct. That's what I'm saying. Because the state government has provincialized the schools as per that act of 2011, as your lordship rightly mentioned, from the date of the thing, that coming into force, their provincialization takes place. If
No, but the stand of the state is clear that without that notification, we have not given the benefit unless there is a court order.
Where is that?
That is what he is
No,
saying.
no, what he says is different.
I can put in an affidavit, my lord.
Yes, you put the papers then,
I can put it.
because.
If
what is
required,
the
my lord, I can
requirement?
put the provincial order of 41,000 people. I can put the provincial order of there also, my lord. If my landed senior prince
No, no.
wants to put me, my lord, I can put it also, my lord, on record. my lord.
Let us have a look at the act for a moment. Section 10. What is the procedure? The procedure is under 10. There shall be one district scrutiny committee in each district separately for elementary and so to scrutinize service records and other related issues of the serving teachers and staff of the venture education institutions pertaining to provincialization of the service. That is the first step. District committee. Deputy Commissioner of the district by an order shall constitute that we are not concerned for different bodies, different authorities and committees will be formed. Then we look at 4. District Scrutiny Committee shall forward it a verified list of eligible teachers school-wide in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their services provincial. This is the requirement. So, District Scrutiny Committee forwards the list to the director scrutinizes and forwards it to the state government for consideration and for issuing notification in respect of eligible institutions and employees eligible for getting their services provincial. If this takes place, which means, that after the scrutiny, if the state is satisfied that because the institutions are already scrutinized, they have to satisfy that condition of 7 years, earlier 10 years. If that is satisfied, the institution gets provincial. Once the institution gets provincialized, the teachers come, and that is controlled by the schedule. Therefore, these 3 committees will scrutinize the eligibility of the teacher. And after they scrutinize and they find that these are the teachers who have to be who are found to be eligible in terms of our schedule, they will issue a notification of the eligible institutions and employees eligible for getting their services provincialized. Now, and what have we produced before your lordship? Exactly the same thing of 15 February. The list is there. The details of the institutions are there. The names of the eligible candidates are there. What more do you want? It is all in public domain. It is published. We have shown that connector A to petition 15.
But if the act stipulates
Yes.
issuance of a notification,
Yes.
isn't it the requirement that the notification has to be issued?
With great respect, how would you constitute? It says that these are the 400 odd schools. Well, to take a practical view, in the line of after this scrutiny, and they give all the details about the institution and also about the teachers who are found eligible. Names of the schools and employees eligible for provincialization under Section 4.1 of the Provincialization Act 2011. This is the list.
But doesn't this notification has to be a
What else
notification
is
by
a
the governor?
notification? It is only for the purpose of what? Notification in respect of the eligible institutions. You want to inform the concerned persons who are interested that these are the institutions which are found to be eligible and employees eligible for getting their services provincialized. And you are saying there the names of the persons whom you have found to be eligible. And you are saying that these people are eligible. What more do you want? And finance department goes, others have got it on the basis of the same procedure. And that is what Dilip Das says, that you don't require any further order formally. This is enough for the purpose of eligibility and provincialization.
But
And
what do
that
you
is
say
repeated
about
by another coordinate bench, single bench judgment, which you have annexed of Justice Casey.
that I've seen it, but
Take that view. And
what
I'm
does
told-
what do you say?
Yes.
Section 3 says, as regards consideration for eligibility.
Correct.
Section 4 says eligible institutions.
Section 3, if you like to kindly have a
Yeah.
look. Eligibility criteria for selection of educational institutions for provincialization of service of its employees. So 3 relates to institutions and the eligibility condition is mentioned.
Because section 3 says
Yes.
categorically that which
Subject-
are the schools which will be for the purpose
Yes.
of
The following categories of venture education shall be eligible for being considered for provincialization of the
considered.
service of its employees. The venture education in institutions which have been established and had obtained the required permission or recognition or affiliation or concurrence as the case may be from the respective competent authority or authorities on or before 1/1/2006. That's the one. 2, it has minimum total enrollment of 25 students if it is a primary school, both lower primary and upper, 25 students in class 10 if it is a high school, 25 students in class 12 if it is a higher secondary school or junior college, 25 students in the final year of 3-year degree course if it is a degree college, as on the date of coming into force of the Act. This is the second eligibility for the institution. In case of high school or higher secondary school or junior college or degree college, the concerned education institution must have a consistent good academic performance, which would mean that at least 30% of the candidates appearing for the final examination must have passed in any 3 examinations held since 1/1/2006. This is the third about the passing of the students, 30%.
no. My therefore question is
Yes.
section 3 categorically says about considered to be considered for being eligible.
Correct.
Eligible for being
Subject to the
considered for
selection of
provincialization.
The following provincial categories of students, institutions shall be eligible
For being considered
for provincialization of the service of its employees.
subject to these conditions.
These are the
Then
conditions.
again in number 2 also 3(2) you see
Yes,
these are the all these things, and then the last 2 line shall be considered for provincialization under the provisions of their only if specified eligibility are satisfied. So this is again considered for provincialization.
correct.
Whereas if you see section 4, the services of the employees of all eligible
Subsection 3 also
venture
is
so and
important.
so under it shall be deemed to be provincialized.
This is below the subsection. It has for the institution, there's other eligibility criteria also that is mentioned in 2 and 3 also about the infrastructure, land, and all that stuff.
Now kindly come to
So-
4.
But
This-
this is for what, Miller? This is for eligibility criteria for selection of education institution for provincialization of service of its employees.
Absolutely. That is what I'm saying.
First, the institution. If the institution is not provincialized, the service doesn't count.
Cannot.
Therefore, 3 contemplates the criteria for judging an institution, whether it will be provincialized or not, if they fulfill this condition. If
So,
they fulfill,
therefore,
they will be.
Section 3
Yes.
says these are the requirements
Yes.
for which you will be considered, the college or the venture institution shall be considered for provincialization.
Yes.
But once you are considered and become eligible,
Yes.
you are deemed to be provincialized in view of
Correct.
court.
That is how Miller they will judge, and
Absolutely.
if these conditions are fulfilled, the district committee will say that this is fulfilled, therefore it's eligible institution. Once that happens, section 4 comes in.
Therefore,
Kindly see section 4 then.
yeah,
The services of the employees of all eligible venture educational institutions under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from the date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into force of this act. So, the scheme under the 2011 Act is, first you see the institution, if it is eligible, then section 4 immediately comes. And they say that the services of the employees of all eligible venture education under 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 7 years of so and so. So it not only makes them eligible, but also state government employees from that date. That's the 2011 Act implication. And the list which we have annexed below, which our lordship has seen already, name of the schools and employees eligible for provincialization under section 4(1) of the Provincialization Act amended in 2013. 4.
so without there being an order of provincialization of the institution, can there be a provincialization of the services?
No, there is a list of institutions which have which satisfy that, and that list contains the names of the institutions.
So your submission would be
That is
that
in
if
15.
the institution is eligible
Yes,
in terms with what is given under 3,
3.
then automatically
4
they
comes
come
in.
within 4.
Except the only condition is the schedule. Schedule A. Number of teachers and all that. And that is under 4(1) this list. B list is that the other list. Here also the name of the schools are mentioned. And the, for example, all the details are mentioned in fact. Past percentage mention everything. It's a format, Milo. They have
But without a notification under section 10(4), can the government take over the institution in view of section 6?
your lordship has seen section 3 and 4. If you read it, it is from the date the employees become, the institution becomes as soon as they satisfy that requirement on inquiry.
But what do you say about section 6?
Section 6, yes, can you see section 6? What is this? With effect from the date of publication of the notification under subsection 4 of section 10, the superintendence and control of all education institutions coming within the purview of this act shall rest in the state government. Correct, Miller? Even without this, already that has come by operation of law and under section 3.
But the state can't take it without the notification under 10(4).
10(4) notification is not only for the purpose of the result of the scrutiny.
Understood, but
Correct.
if
And
you
they
have section
say,
6, without the notification, the state
no,
can't take
what
it.
is the notification that is contemplated under 4, 6 and 4? The district scrutiny committee shall forward the verified list of eligible teachers school-wide in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the name to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their service provision. After the scrutiny, how will they scrutinize an institution? They have to go to section 3. You find that X institution is satisfied. Then automatically 4 comes. Then they'll have to go and see whether how to enforce the schedule and get the eligible candidate. That's the second exercise they'll be doing, district committee. They have done, they will forward it to the director, director will scrutinize, then it will forward to the state government. And what for? For notifying the people that these are the institution, these are the eligible candidates. For one.
So if we read the Justice Buzarbura's judgment,
Yeah.
he treats the notification to be an administrative order.
No, what he says is by operation of law, it becomes right has accrued. You don't require a further administrative order to supplement. That's the view.
So,
That is the
because
view.
the words used here,
Yes, I'll show you a lot. Kindly have a look at it. His judgment is at page 94. No? I'm sorry, Milord, if I'm your lordship is taking a different book. If what is the item number 9? Monima data?
kindly come to page, you are referring to Onima Deka, then you kindly come
94.
to page
94.
kindly come to paragraph 14, page 98.
Yes, you know.
Page 98, paragraph 14.
Yes. In view of the above, as the service of the petitioner should provincialize under section 4.1 of the Act of 2011, the court is of the view that there is no requirement of any further administrative order by the department to provincialize his service, and all that is required is to recognize that the service already stood provincialized under section 4.1 of the Act in the facts and circumstances of the present case. And if your lordship sees the facts, in the instant case, as already concluded herein above, the petitioner being included within the numbers specified in the schedule, and there being no other impediment, his service should provincialize by operation of law under section 4.1 of the Act 2011. Therefore, the case of the petitioner could also be covered by the provision of para 19 of the decision of the division bench of this court dated 2/1/17, that's the review case, in review petition so and so, and the benefits of provincialization that accrued to him by operation of law shall remain. Then 14 comes, and then he clarifies, it is clarified that this order has been passed upon an interpretation of the provisions of section 4.1, read with 10.4, and the schedule to the Act 2011, and has been passed only upon the circumstance that prior to the Act of 2011 being declared expiry, the authorities had already arrived at a conclusion that the petitioner is included within the number of posts under the schedule to the Act of 2011, and therefore, it being so, his service to provincialized by operation of law under section 4(1) of the Act. It also provided that as even the government had accorded their approval to the aspect that the petitioner came within the number of posts provided in the schedule before the Act, was declared ultra vires, the provisions of the order do not constitute to provide that provincialization can still go on under the 2011 Act, even in the absence of the situation based upon which this order is passed. And if your lordship kindly turn to para 11.
Para 8 also, page 97 if you come to,
Oh, para 8.
where third line, provision of section 10(4), third line.
As
on the top.
already noticed earlier, the service of the concerned employee should provincialize.
Third line from the top. Provision of section 10(4) is merely
Uh,
third line, page 97.
Yes, any such order that the authorities may pass would be only in the nature of an order recognizing the provincialization of the concerned employee, which had already taken place by operation of law, and such order of recognition cannot be construed to be an order provincializing itself. So the learned judge makes a distinction that once the operation of law makes him provincialized, and then it is recognized, recognition is given by this. And para 11, then Miller, a stand has been taken by the authorities of the Higher Education Board that by the judgment and order dated so and so, that is the main judgment, was declared to be ultra vires. According to the learned and the Council for the Higher Education Department, it is the view of the department that as the Act had already been declared ultra vires, therefore no further order for provincialization of the petitioner can be effected by the department. It is taken note of that, although by the judgment on order dated 23/9/16, the Act of 2011 was declared to be ultra vires, but by a subsequent decision on 2/1/17, review petition number so and so, it had been provided that the rights of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so decide. Until then, the services of the provincialized category and their status as government employees shall not be disturbed, and they will continue to receive all the benefits which they are getting under the Provincialization Act of 2011. In the instant case, as already concluded here and above, the petitioner being included within the numbers specified in the schedule, and there being no other impediment, his service to provincialize by operation of law under 4(1) of the Act. Therefore, the case of the petitioner would also be covered by the provision of paragraph 19 of the decision of the division bench of this court dated 2/1/17 in review petition, and the benefits of provincialization that accrued to him by operation of law shall remain. In view of the above, as the service of the petitioner is provincialized under section 4(1) of the Act, the court is of the view that there is no requirement of any further administrative order by the department to provincialize his service, and all that is required is to recognize that his service already stood provincialized under section 4(1) of the Act in the facts and circumstances of the case. So that is the view that is taken, and which view, my lord, has been approved also by another single judge, page 100. And I am told, my lord, my friend, that there are a lot of other cases where these judgments have been followed. The 101.
But the decision means Other decisions which have been following is just following
Follow.
after quoting the entire judgment.
This is also one of those judgments, you know. At 101, he refers to that judgment. And then court by so made the following observations, and then it is quoted below. In other words, his lordship agreed with the view of the earlier. Your lordship is right, it is quoted. Accordingly, the present petition is disposed of, directing the respondent authorities.
Mr. Goswami, if I may just put another question to you.
Yes.
This judgment of Justice Buzargura have been implemented, as you say. They have already implemented and given the benefit. Now, the Supreme Court in various judgments have said there is no estoppel or rejudicator who applies. But if it is a case of pick and choose, then the government can't resist, which the government is doing now. Don't you think that those 41,000 which they have provincialized without a court's order, without a notification, would be a case of pick and choose?
In a way, your lordship is right. In a way, if you have done in respect of a number of schools that they are eligible, and part of it you have provincialized and paid, part of it remains. It's all because of the little lackadaisical approach of the officers in the office. Otherwise, these notifications came in 2015. So far we are concerned. After finance, it was published 2015. And your lordship has seen the press release approval given 2011.
Press release is of 2014. Those annexures which you have enclosed is of 2015.
2015, that notification. February 15. Huh? And the press release is 14. And they refer to the earlier 2 years where how many people were.
In fact, the judgment of Justice Buzargura also takes note of this judgment, means this Purnavati Brahma.
He is a party to that second
judgment, but
bench.
in this judgment where he is saying that the question of not getting the, as I was saying to him, if he didn't get any benefit, then you can't give a direction on a repeal that. But he has, by dint of law, having already got the benefit, as have been observed in paragraph 13-14,
yes,
he will come within the ambit of that.
That case, cited by my learned friend, because it must have noted that he was district selection committee didn't recommend him. Purnavati board. That paragraph, I think, your lordship is waiting for you.
Okay. Would you like to say anything further? Have any further submissions?
Really speaking, I
No.
have covered.
Then I will close it and keep it reserved then. Or anything else you want to submit, then I can have it at 2.
I will just come
Okay.
for 5-10 minutes. We'll just complete.
Item number?
37. Maybe they can some other data.
37 is what matter?
Discipline procedure.
Ask your junior to be there. I'll pass an order.
But just very briefly, we will just deal with these two judgments cited by my learned friend. The first one is Purnavati Brahma.
Ah.
Like they were really on the facts. Paragraph 4 and 9. In this Purnavati Milord, the doctors find that page or paragraph 4 about the bottom Milord. Despite such a recommendation by whether her name should be there in the list or not was the question. Because to see the fact, there was a language teacher, Boro and Assamese, despite such recommendation.
Last 4 lines of paragraph number 4.
Yes, that is what I was trying to. Her name was dropped as it relates to the service of the consequently. Paragraph 9. Paragraph 9 is the finding. The case is projected by the learned counsel for appellant to the effect that the appellant was vested with rights under the Act of 2011 on the date when the judgment was rendered in Chandan Kumar. That is the first case, cannot be accepted. The very fact that the services of the petitioner had not been provincialized and therefore the petition was filed makes it clear that the case of the petitioner would not be covered with the 4 corners of the petition rendered on the refusal. So basically, whether it should be provincialized or not was the question. And that was delegation. And this Guru Nath, Commerce College case, similar is the question, whether the petitioner or the respondent number 5 should be included. The petitioner was held to be an access person and therefore he was not provincialized. And that is a absolutely different question than what we are.
No, but if you see the last in the middle, that's until and unless the verification process is completed at the level of the state government, consequent upon which provincialization notification is issued, the rival claims to provincialization would remain within the realm of verification and without any finality attached.
That's what I'm trying to say. Because the question was who will be the person who is entitled, because there were 3 folks. Sportsman was an access. The petitioner was the access. Therefore, under the schedule, the number has to be 3. Therefore, they said that once that verification is continuing, nothing accrues to anyone. So that has to be verified. Ultimately, they found that respondent number 5 was senior to him and he was put in release. And respondent number 5, who is the petitioner, was in the access category. If it is access category, you are not included under the 2000. Under Dilip Das, in fact, is the respondent of whose case ultimately came, and that decision of Justice Pujarwar, that he has acquired the right authority because his name was written.
So your submission would be, irrespective of the school being provincialized or not, if a school otherwise meets the eligibility criteria and the verification in respect to the employees will be only limited as to whether they fall within the Schedule 1. If they fall within it, then automatically by virtue of Section 4,
They get pro and treated as state government. That's this scheme. So these two decisions really on facts are different. Otherwise, we have placed in our replies the format which they have prepared after scrutiny. The institution is mentioned, the eligible candidates are mentioned, everything. And that has been and I need not cite cases. These two judgments have been followed in several cases, I am sure. That Dilip and the other one, page 94 and page 100. In fact, as you look at it, even page 100 judgment actually quotes them. But that is how it is. So that view is there. Therefore, normally, lordship, with that a coordinate bench will have the option of referring to a division bench. Say there is a serious disagreement. Otherwise, normally it is back. I don't have to cite cases, but latest one is from 2017, volume 16, SCC 468. Judgment by Justice Sunderfield. One or yes, constitution. Goes into the question. There are lots of no doubt, but I am only just right. So well known to it. Two cases cited. That Manipur case is a different case altogether. It has nothing to do with. And in our case, the review order protected us even after declaration. So, and then the new law also protected by 20. So,
now as regards the division bench judgment,
yes.
Justice Lamba and Justice Buzarburwa,
Yes.
the facts are different for the fact that that person concerned was dropped.
Yes.
And as such, when he was dropped at that point of time, there was a decision already taken to the effect that the person has already been dropped. And as such, the question of getting the benefit under the 2011 Act did not arise.
Did not. That's right.
But on the other hand, in the case of the petitioners, there has been those in the internet, this has already been published, which have been duly admitted in their affidavit also, that there was a publication. But Mr. Gustami, only one thing is having, and this court is finding it difficult is section 6.
Section 6. I'll again read it later. So, section 6. With effect from the date of publication of the notification under 10.4, the superintendent and control of all educational institutions coming within the purview of this act shall vest in the state.
So can we say, being the notification to be a mere administrative order?
No, sir. The notification is the product of this scrutiny, which is contemplated by 10. How do you make it public? Is a mode of procedure. If you earlier times there was only a notification. Here you have a technologically better system. You are putting it in the website. They have admitted this is their own website, and therefore they are doing it. And there is a press release also, as your lordship has seen. That also is a mode of publicity. What is the object behind that 10.4 publicity? You are having an act prescribing the eligibility for the institution, prescribing the eligibility for the teachers in the schedule, and thereafter the scrutiny process is provided in 3 stages, and thereafter 10.4 says you notify. How do you notify is your business. You can notify through the website which says that this is the institution, these are the people. So people can come to know the result of the scrutiny.
Can there be a notification of a government order which is not in consonance with Article 166? Because there is a long
of the publication of the notification under subsection 10 of 4 of 10, the superintendent and they all come up. So 10.4 is the scrutiny part. Scrutiny results in a particular situation. X number of schools found suitable. These are the employees who are treated to be. This is all that is required. It is like declaring a result.
No, but in a result, if a person is to be appointed or given some select list may come, but a person has to be appointed by the government, then in that regard, the notification has to be
issued. That is an appointment process.
Yes.
Here, the main section says once the institution is there, then you are deemed to be provincial. That is section
4.
The services of the employees of all eligible venture educational institution under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from the act, provided that institutions have completed at least 7 years of imparting education and all that. The moment you find the institution to have satisfied the requirements, the employees contemplated under the schedule are provincialized. They are treated as government employees by this. From that. So this is a right which is accrued even before the review judgment, because all these notifications were issued under in 2015. So the institution is mentioned, the eligible employees are notified, so it is, and part of it is, they become automatically, that is why the judgment says it is by operation of law you have done. This law makes it clear that once that is done, it is you become a government employee. You don't require any further notification. This judgment has notified on that. That is the whole issue which was decided. Namely that, do you require anything further to be done after this scrutiny and this website comes? No.
But the judgment does not deal with section 6.
No. This is consequential. Huh? This is a consequential provision.
But if it does not vest
It
with the
follows
state,
from it follows section 4.
but if it does not vest, if it does not vest upon the state, how can the state exercise control over it as a provincialized employee?
We don't see what will help in this state. The moment the institution satisfies the eligibility norms, it becomes a eligible institution which is notified, and then government becomes the owner of that. It rests by operation. This is three is eligibility criteria for selection of education minister for provincialization of service of its employees. Subject to the provisions of 30, the following categories of venture education shall be eligible for being considered for provincialization of the services of its employees. Then the institutions are mentioned and the eligibility norms are specified. And once that is done, my lord, then there is nothing else to be done. That is the part of the district committee then comes and they will determine whether they come within the four corners of this section 3. The moment they come to a finding, then 4 automatically takes over the eligible person. There is these rights accrue. That's the finding.
So the declaration which you are asking in this petition, that the petitioners, the school of the petitioners has provincialized before 23/9/2016. That is the declaration you are seeking.
That is the admitted position.
It is
they have
on the
admitted that notification.
It is on the basis of that declaration.
That is
section 6 will operate.
The moment you have declared this institution to be eligible, I automatically become eligible for provincialization under section 4.
And that declaration will have the impact on section 6.
That declaration will only go to show that the institution which is found suitable will come under the government's purview. This is the whole thing is a provincialization act, you know. These are private institutions which have sprung up over a period of time. The object of the act is to make them government, provincialize them. So what is the procedure? Procedure is prescribed. And once the eligibility norms are satisfied by the institution, there is an end of the matter. That is notified, and then they will be automatically coming under the provincialization of an institution. There is nothing special about it. Once you satisfy that norm, you are becoming a government institution. Otherwise, it remains a private institution. That is also mentioned.
Now, you see section 24 of the Act.
Of this one or
of the 2017.
Correct. Therefore, I divided the thing into 3 parts. First part is the 2011 Act, which has been given effect to. Second part is the review part, which again protects those rights. Third part is now the 2017. Once these rights accrue to some of these provincialized people, as the additional Advocate General told the review court, 40,000 in numbers. What can we do? Therefore, those rights accrued under the 2011, just like ours. Once that happens, our school gets recognized. We are provincialized. Our schools are provincialized. Our teachers are provincialized. And that is what is meant by that notification, section 4. There's nothing special about it. And then comes 2017. 2017 doesn't determine whether my right has accrued under 2011. That your
No,
lordship
that would it not.
Ah.
But what do you say? Section 24 gives the power to the authorities to review.
No, that is, I'll address it. Let us first go to the. '24. Repeal and saving. The Assam Venture Educational Institute Act 2011 as amended by so which have been struck down by the Honorable Guwahati High Court by order dated 23/9/16, and all rules and orders notification issued thereunder shall stand repeat. However, all the teachers whose services were provincialized prior to 23/9/16 shall continue, and their cases shall be reviewed as per the eligibility norms set forth for provincialization under this act.
Now, if you see their last of the affidavit, they have mentioned that after the 2017 Act, they have made further inquiries in terms with the requirement under the 2017 Act.
Let me tell you a lordship one. I'm not part of that case. But 2017 that has been raised and it is pending. And my learned friend is appearing there. And there the learned Advocate General, I'm told, has already told the court that no review or inquiry with regard to those who were provincialized under the 2011 Act are yet to start.
No. It is given out there in the affidavit.
Correct. They have the power to do it. And there is a scheme under the 2017 Act for that. But nobody has been reviewed under that Act so far.
No. Your schools have been reviewed out there.
No, I don't think so.
They say that and after that it has been found that you don't meet the criteria as per the 2017. Because
Absolutely. If they're projecting on that, they're going to absolutely nowhere. The Act is which will apply so far as this institution and these employees are concerned is the 2011 Act. The rights which accrue to us are under the 2011 Act. This REIT wants to enforce only those rights which are accrued to us under 2011. Therefore, 2017 Act has nothing to do with regard to that. And 2017 Act in section 24 has given them has saved this right, but given them a right to review. One concerned, we are not challenging any order passed by the government under 2017 Act. There is no order given to us under that act which we have challenged before your lordship. None. We are only saying that look at our history compared to all these provincialized schools you have. Same procedure was followed for us. Same procedure of notifying was followed in our case, and our institutions are provincialized. Our names are there as eligible candidates. Therefore, we are in a provincialized school, discharging teachers' job in a provincialized school. Therefore, we are saying that others are getting the scale pay and all that, we are being deprived. Therefore, we are before your Lord. And that is the issue which has to be decided. Whether we satisfy or whether our school satisfies 2017 Act, it is not given retrospective effect.
Or in other words, we can also say that Section 24 only gives them the liberty insofar as the employees are concerned, but not the schools, because the school having already been provincialized.
See how inconsistent they are standing. Before the review code, you have seen the submission.
Because if you see Section
Correct,
24,
your lordship is absolutely right.
however, all teachers whose services were provincialized prior to year shall continue and their cases shall be reviewed as per the eligibility norms set forth for the provincialization under this act. Meaning thereby this is only in respect to the teachers.
Correct.
But here the affidavit says only as regards the institutions. But your submission is the institutions having already been provincialized, you cannot now touch upon.
No, it will create a chaos. If that is done,
Because
that's
otherwise-
why, the state is telling the court very frankly in the review that we will be in a soup. No, sir. Section 7(2), my learned friend wants to take your question. That tutor, even suppose he doesn't fulfill, he will continue with that.
That I know.
Your lordship. But that
Their time is given to fulfill. But this is not as regards that, because their affidavit says about the school having not.
correct.
Because if this view is being taken on Section 24, then in that case, the problem which will arise later on is what will happen as regards those provincialized schools of 1968.
Absolutely, your lordship is absolutely.
But Mr. P.K. Goswami, the learned senior counsel, assisted by Mr. P.P. and Mr. N.J. Katuni, the learned counsel, appearing on behalf of the secondary education.
Here, my secondary readings.
Hearing completed, judgment reserved. Yes.
Last submission, madam.
Yes.
Regarding Dilip Das case, why it is not applicable, madam? Because the commerce stream of this Paschim Guwahati Mahavidyalaya, it was provincialized on 20 January 2014, and the Dilip Das case was decided on 2018, my lord, because his post was kept vacant, my lord, because of the interim order of this honorable court. So this college was provincialized earlier, my lord. So my lord, that's why this Dilip Das case is not applicable in this case, my lord, because here institutions are not provincialized. Here, my lord, except Dilip Das.
No, Mr. Katuni, whether the school is provincialized or not makes no difference, because your submission is on the aspect of 10-4.
Yes, my lord.
A notification having not been issued.
Yes, my lord.
Till late. So under such circumstances, no right accrues upon him.
Exactly, my lord. That is why I am saying, man, this college, this has been provincialized in the year 2014, and the issue of Dilip Das decided in the year 2018. So, my lord.
But if you see paragraph 13, 14, 15, 16 of the judgment
Yes,
of Justice Buzar, he does not go into that.
Exactly, my
he
lord.
gives a reading of
Exactly,
Section 4.1 read with Section 10.4 and say that no administrative, it is merely an
That
administrative.
is, my lord. In that case, my lord, Section 6
But
will
you
not
have-
come, my lord.
But you have not challenged that order.
That's a completely different thing, my lord. Because, my lord, here, my lord, the college was provincialized earlier, my lord. College was provincialized earlier. The only case of one employee, my lord. Here, my lord, the case of provincialization of the institution, my lord. And because of that, my lord, 6 notification is required to apply this provision of Section 6. 10 for notification is required, my lord. And regarding 2017, applicability of 2017, they are relying on a list published in the year 2015. And the Dilip Das order was passed in the year 2018, but they have filed a petition in the year 2020 because they have waited for result of 2017 verification. When it was negative, then they took the help of Dilip Das case, my lord. This is the real fact, my lord.
No, we have said.
They have not explained the delay, my lord.
you
While
are-
preferring the petition, they have not explained.
We are on a much better point. Let us deal with that instead of taking the argument of fence sitter.
I don't know.
We'll take it up. Don't worry.
Well, I have given this order of provincialization of Dilip Das college, my lord. Obliged, lordship.
Instead of telling the Philip that in that event, we have come to us.
You're challenged it?
No, my lord. Dilip Das case.
No,
As per-
nobody challenged, and that has been followed in innumerable cases.
That cannot be a ground, my lord. In case of my lord,
Of course, it is a ground.
BJ
that case has decided
Akkar
that-
case, my lord, that cannot be ground, my lord. In case of 2006-11, the SSC, my lord. My lord was my lord
BJ
was-
Akbara.
Yes, my lord.
No, Akbar Ali doesn't say that.
And in fact, my lord, in case of Rashna Hills, my lord, the beam provision, I have gone through it, my lord. To some extent, it helps us, my lord.
Yes, Mr. Barbara.
Obliged, lord.
Your matter. What did the finance do? You're waiting for that matter?
He had some tranquilizing effect on me. I would all these arguments, my lord. I was feeling sleepy. Proceeding is otherwise lively. My lord, the matter of the video, my lord, we promoted some video,
Yes, sir, I remember.
but we are not. We were getting the same pay grade.
Yes, I
Last
remember.
time, my lord, on the last.
I remember. I have asked the finance
Yes,
to.
rules.
There's a fight between the finance and the.
Yes. Our Panchayat commissioner is supporting me. And me, 10 out of 5 out of 10.
Okay, let me first take up one matter that is the top of the list because you know the reasons. The top of the list, let me complete it.
Here, my lord, the finance.
Finance will come.
Finance
I'll take up your matter. Just let me start with the top of the list matter.
Nice
the
matter.
2013 matter.
Very council applying for finance will have to be here.
Yes.
Council Bigo is on his way.
Who?
Finance. Council Bigo.
Okay. But let me first take up that matter.
Lord.
Top of the list.
Item number 39.
Please, your lordship, sometimes maybe kindly possible for the time being, lordship. My senior is coming, lordship.
Hey, National Highway. Yes. Mr. Borwa, tell me,
My lord.
how are you filing a writ?
Because, my lord, I have challenged the order passed by the learned ADC. This is a jurisdiction matter.
Why?
Because he was not even jurisdiction. Right?
He was not appointed.
No.
The power was given to the secretary.
That's our proper moment. This is regarding national highway matter, equation matter. It was power either by arbitrator or by competent authority method. This particular ADC is neither competent authority nor is an arbitrator.
He's not the competent authority.
No.
And
He's
competent
neither,
authority has been defined and means any person or authority authorized by the central government by notification in the official gazette to perform the functions of the competent authority for such area. So he does not come under 3A.
no. He doesn't
Neither
come
he is an arbitrator, is to be appointed.
by central government. This arbitrator is an appointed arbitrator, my lord. He should be appointed arbitrator. He was appointed.
But he was not appointed, he was not an arbitrator.
No.
The arbitrator will only come into when there is a dispute.
Yes.
And
Here-
then the matter has to be referred.
Here what happened, my lord, when claimant has received the money, after receiving due compensation, they have challenged the matter. They're supposed to go to learned arbitrator. That application is filed under section 373G75, my lord, NSA. Lordship may peruse. Here,
3G7.
but he has filed this application before the deputy commissioner. Thereafter, it was handed over to additional deputy commissioner. That is why this additional deputy commissioner acting as a civil officer, civil judicial officer here. That is my challenge before Lordship. Once he is neither his competent authority nor arbitrator, he cannot pass an order. That application was filed before the that DC.
I've got your point. No worry. Yes.
Lordship, my senior is coming, Lordship.
But why the matter has been pending for 10 years?
Yes, that is the decision Lordship see from very 12, Justice 2012 his order passed. Thereafter it was hard. I should not all these things to get delay some reasons. It is hard by the orders. It's a very lengthy one, Miller. Most of these honorable judges have heard this matter, and it was kept actually for last occasion. It was kept for order. Necessary order means it amounts to that time it was judgment reserved. Seems to be like that. It was after hearing all this matter. But anyhow, this matter today suddenly yesterday night we have.
Yes, Mr. Counsel.
My lord,
You are appearing for whom?
I am for 789, my lord.
Okay, tell
They
me,
are the-
how is the additional deputy commissioner the competent authority?
Here, my lord, case is different. My lord, in 2012, the suit filed before the civil court. And that time, my lord, no land acquired. And after the continuation of the suit before the deputy commissioner, my lord, he is the civil judge. That time, my lord, land acquired. When land acquired, my lord, after that acquisition of the land, competent authority come, my lord, for determination of compensation. So before that, my lord, this National Highway Act, the provision of the National Highway Act 1956, not applicable. Because when we have filed a suit, land which they have encroached of the villagers, that time, my lord, land not acquired.
But Mr. Counsel, the order has been passed under section 3G7.
That is, my lord,
I would have understood if he
Order
has
not-
passed, if he has passed the order as a civil court.
if your
Very
lordship, if your lordship will go with the annexure A of my affidavit in opposition, that affidavit, my lord,
No, no,
that
but
order-
Mr. Counsel, kindly appreciate one thing.
Yes,
The
Murati.
order, the section under which the order is being passed.
Order passed, my lord, in terms of the provision laid down into the Administration of Justice Act.
No, the order is being passed
No,
in
that
respect to 3G7. This is clear. In
No,
miscase under
because, my
section
lord,
3G7.
Deputy Commissioner only passed the order to make the payment. And Deputy Commissioner,
This is a judgment passed by so and so. That is annexure 9. See the annexure 9
No,
of the petition.
I have annexed the judgment, my lord.
Isn't this the order? Judgment annexure
I
9
have
of the
annexed-
petition.
My lord, they have not annexed the cost title, my lord. Cost title, they have not annexed. They have annexed the part of the judgment, my lord. I have annexed the whole judgment
Where?
in my affidavit in opposition, my lord.
Show me.
Page 16, my lord. Annexure A2. So cost title, that portion they have not annexed.
Hmm.
And construction company, one of the defendant in the suit, my lord.
Hmm.
But they have not been made party into the proceeding, my lord, in the writ proceeding, my lord.
Hmm. So
That is five,
kindly
my
come
lord,
to,
project.
kindly come to page 18.
Page 18, my lord.
Hmm.
It is a Deputy Commissioner mentioned that petitioner has filed a petition under so and so provision, my
Hmm.
That is a claim, my lord.
Hmm.
Initially, we have no idea what was actually happened with the villagers.
Whatever
But-
may be, whatever may be,
that
these
is a
whatever may be, first
Wrong
of all, it
reflection
has
of
to
the
be.
law, wrong reflection of the law does not vitiate the entire proceeding, my
No,
lord. Question is-
your entire matter was filed under the National Highway Act.
No, that is a claim, my lord.
That is what your claim is
Claim-
made under under the National Highway Act.
When we have made the claim, my lord, that time survey was not conducted.
Not necessary. Kindly
No, my
see.
lord, question
No,
is,
no.
my
Kindly
lord.
see. Kindly see this
That-
act.
That
National
act,
Highway
the
Act.
provision of that act will come later on, my lord. Section 3G, my lord. What says, my lord, section 3Z? Competent authority can determine the compensation, determination of amount payable as compensation where any land is acquired. The competent authority cannot come and determine the compensation unless and until, my lord, land acquired. That is the law, my lord. So competent authority has nothing to do unless land acquired. So in the year 2012, my lord, should file before the civil court, my lord.
Mr. Borua, kindly tell me when was the declaration made?
Declaration was made in Millard. That is in annexure A, that is annexure 1 2005, Millard. 2005.
2005. Declaration has been made.
That is different land, my lord.
That is declaration on
That land not, that land acquired, our land not acquired, my lord.
that is
Our land not
February
acquired.
2, 2010 notification, Millard.
That is a different land, and for a different land, competent authority determine compensation. But our land not acquired, my lord. Our land enclosed. That is why, my lord, should file before filing of the suit, my lord, 80 CPC legal notice served to them. And they have admitted in response to the said legal notice, my lord. According to the National Highway Authority, my lord, they shifted their burden to contractor, my lord. That is Hindustan Construction Company. And it is a liability of the construction company to make payment of the compensation to the affected person. This is a response of the FTCPC notice, my lord.
Yes, Mr. Yeah, kindly show me.
My
Which is
lord,
the land.
your
Mr.
lordship
Borua,
may
My lord,
kindly
land,
show me the
I have
land
to-
which have been acquired.
Lordship,
Where is the declaration?
Lordship, I may be permitted to little bit. Here, Millard, your lordship will get it. We have given that is notification under this one. TA notification was issued on Millard. The lordship will get it in first page. Annexure A, page 17, Millard. The English version is here, Millard. Lordship got it, page 18. February 28. In excess of powers conferred by clause, the Ministry of Civil Protection under section
Page?
Here, Section 3 of National Health authorized central government hereby authorized Secretary Revenue and Sea Hills Autonomous Council along Assam is competent authority to perform the functions as authority as the act with the effect from the publication notification in the official gazette. This land from 66 or each one on National High and Sea Hills Miller. This is notification, then
No, where is your papers pertaining to acquisition?
here, Lordship. Let's Miller Lordship may I can
My lord, I have annexed some documents, my lord, along with my affidavit in opposition.
After element.
In my affidavit, I have annexed some documents, my lord, and all those documents is the certified copy which I obtained from the LCR, my lord. And that document speaks that, my lord, they have conducted trace survey, my lord, in respect of the affected. And after that, my lord, it was confirmed that some other land they have used for construction of 4 land. And thereafter, my lord, when it is come to the knowledge of all the parties, my lord, UWD, NS National Highway Authority, Forest Department, Land Revenue Department, my lord, then, my lord, they have taken a decision to acquire the land, my lord. All documents I have annexed with my, these are the documents available in LCR, my lord. When land acquired, my lord, then competent authority come for determination of compensation, and accordingly compensation determined. And that report submitted before the court, before the civil court at Hapur. Then Deputy Commissioner has considered the report and passed the order to make the payment in terms of the determination made by the competent authority. This is the case, my lord. But they are projecting a different case. They are saying the Deputy Commissioner is not a competent authority. This is wrong to tell you, my lord. Deputy Commissioner never determined any compensation in the case, my lord.
Who is appearing for Dimaso? Yes, Mr. Konigar. What is this power you have exercised?
The powers exercised by the deputy commissioner. My friend, he is appearing for deputy commissioner. Government is appearing.
Yes. No. First Dimaso. You have made allegation that the petitioners have done that. There is an affidavit filed by you. The deputy commissioner has not done it. You have made an allegation in your affidavit, as I could see. More particularly at you are the respondent number 3.
No, I am not 3, but
Who is 3?
is
Additional Deputy Commissioner
Yes.
Dima Hassaf.
Madam.
Yes, tell me. What is this power you have exercised?
In your affidavit lordship, page 2, bottom lordship.
Paragraph 4.
Paragraph 4 lordship. Bottom lordship. Therefore, after observing all legal formalities, the respondent number 789 had taken the recourse of law and instituted a civil suit for damage against the petitioner and state construction company before this competition authority competent ordinary civil jurisdiction for damage as per the provisions of the prevailing customary law, which had been entered in under the provisions of the local act and rules of civil remedy, and accordingly the miscase number 20 of 12 had been registered, and there had been no appeal power for the filing of a suit against the evil doers, wrongdoers, and against the petitioners in the National Highway Act for damage. In the present situation, the petitioners urge the statutory authority to pay statutory compensation for causing damage of non-acquired land and property of the state residents potentially and dishonestly beyond the actual right of way. On receipt of the summons from the learned court of the Deputy Commissioner Dimahata at Hakong, who acted as a civil judge, the petitioners had contested the suit by filing two written statements. One of the month of February 2013 and another written statement was filed 31st July 2013 and also adduced evidence during the course of the civil proceedings. On the other hand, the state construction company also filed their written statement on 2nd July 2013 and subsequently state authorized contractor also adduced evidence from site. At the same time,
that I have seen it.
No.
Therefore, the land in question, Mr. Dimaso, is it a land outside the purview of the acquired land?
In this regard, I have filed an affidavit.
Where? Where is filed? Where is it?
We have received it.
Who has filed that? Additional affidavit. Filed by Devraj Datta. Huh? Yes. Who are you?
Paragraph 2, madam.
Oh, that's the National Highway Authority. Additional affidavit in reply. Okay. Oh, affidavit.
This part is not, this fact was never informed Dimahata.
Affidavit in by National Highway Authority in reply. Counter affidavit by respondent number 7889. No.
Last on
As directed by
24/1/2023 they filed it.
Huh?
24 January 2023. That is by competent authority.
12th of February 2018.
24 of January 2023.
Affidavit by respondent number 2. 24th of January.
Yes.
Yes. Who is
There
this
is
National
competent
Authority?
authority.
The site mentioned by the petitioner seems to be beyond the row, and the Land and Revenue Department have not acquired the said site, nor the NH authority informed the Land and Revenue Department for such requirement of land for the dumping purpose, and as such, taking action is required under when does not arise. So it will be an order being passed under, not under the National Highway or.
Yes, that is I'm challenged before Lordship. He have filed an application under section 3(7).
Whatever they may do, that is a different thing.
NSX, my lord. That judgment was also delivered by ADC under the provision of NSX. What I am saying now, this judgment is he cannot pass this order because he doesn't have power. Jurisdiction. He doesn't have, because before that we have to go his application, my lord. We have to go what application he sought, what application is filed by him before the DC.
Now, what is the status out there in Karbi Anglong, Dimahasa? How does it happen? It is done by the court or the DC? Any further?
Nowadays, earlier it was by the DC. Now
segregated.
Now segregated. After 2013, my lord.
No, not 17. My lord, 29 July of 2017, judiciary segregated from, separated from executive. Now, judiciary is independently functioning in Jatinga. Judiciary have an independent building there.
So
And
this is
before that,
this
my
is a land admittedly outside the scope
Yes.
of the notification.
Yes, my
Is admitted?
Yes,
yes.
but
No, Mr. Burwa, is this admitted that this land in question is outside the scope of the notification or declaration which have been
it
given?
is included.
Huh?
It is also included portion. Here the question is coming, my lord, lordship, the information I'm submitting. Here their petition is not there. After receiving the amount for shade land, they are demanding the money. Under provision, when arbitrator will come? Arbitrator will come when this compensation is not satisfied. Once they are not satisfied the compensation, that is why they have to come under TG, matlab. It's before the arbitrator. But wrongly they have processed to DC. Our submission very beginning also this 12, so we have got whatever this one, if you are coming under 370 before arbitrator, you let us go to arbitrator, whatever it is, they place the arbitrator. Because now you cannot say this is now, my lord, as
Mr. Bolwa, I'm only asking you a simple question.
Hmm.
Is the land which have been acquired because the Dimahaso categorically says is outside the purview of the declaration or the acquired land? Is it outside?
but their claim is inside. That is outside.
This is the outside land. Fantastic. I set aside the order, go to the civil court, and the civil court will decide in accordance therewith.
Or arbitrator, my lord, whatever.
Why arbitrator again?
Because
If it is outside the scope of National Highway Act, then why is it possible?
whatever lord order. But this is not
My
something.
lord, my simple submission is there. Our land acquired, my lord. I have
No,
an
Mr.
exhibit.
Counsel, kindly read. I have read that order. The order does not say on what basis he has arrived to 6 crores. He has just made it on the basis of an inquiry report.
No, that is
You can't do that.
No, my lord, that is annexed, my lord.
I've seen it.
Yes, yes. In the
The
judgment,
inquiry
my
report,
lord.
on the basis of an inquiry report, can you do so without the inquiry officer being made a part out there or being cross-examined? How are you bringing those evidence out there?
The evidence we have adduced, my lord.
Understood. So let the trial court decide on that aspect of the matter, civil court. How can this be done by this manner? We set aside this thing. You see, unnecessarily you get now more money because if it is not acquired, it has to be taken as of now. What has happened to the land?
Used already.
Whatever
Used,
land,
my lord.
You have taken the land, which is outside the
whatever
scope.
land was acquired, land is being utilized, road is in constructed, road is
No, the other portion of the land, which is their land out here, is outside the purview of the.
But we have not, outside the land, we do not use. ROW, beyond ROW, we do not require.
That is, my lord.
Right of way, we use only land which is within ROW, the right of way. Because according to them, it is right of.
No, because
right of
you
way.
see, the respondents have filed an affidavit categorically stating that this land which you have done it is outside the purview.
We not require that land for us. We have not.
So you will be entitled to the damages which you have done. So let him prove it there.
Yes, that is why.
My lord,
here it is there. If it is, my lord,
if
our
your lordship
contractor
will go
segment
to
simple
my
matter is there.
affidavit, my
If
lord,
contractor is
page 34 of my
damaging
affidavit, my
anything
lord.
or dumping anything, he will pay this. That is why, lordship. That is the
My lord,
simple matter.
annexer B.
No, dumping or doing out there is outside the scope.
Yes, that is why beyond it is
So it will be by way of a civil suit, which is outside the scope of the declaration. Any damage which happens to outside lands, you are to pay.
We do not require to pay. We do not require to pay.
Who is going to pay?
Because ROW beyond it is any damage caused by that concerned contractor will do.
So contractor has to pay.
Contractor has to
But
pay.
you have not made him the party.
No, because I am challenging here jurisdiction. Because I am basically my point here, what is jurisdiction? Because that order, which was challenged by me, by ADC, by granting 6 crore 86, more than 6 crore, That is I'm challenging, the jurisdiction part.
What happens to an order being passed by the DC? Where does the appeal lie?
No, here is.
Where does the appeal lie?
Appeal lie here in High Court, as per the local act and rules. But and even also the High Court rules also says that any order passed by the Deputy Commissioner that is appealable order, appeal is to be prepared before the High Court.
But this
This is the provision laid down in the High Court rule.
Demanding on NHA. He is demanding money on the basis of NHA. NHA, DC has no power.
Huh?
NHA, right? Whatever is created by DC, that cannot, he doesn't have power. That is our main point, below.
Why?
Why? Because this is either arbitrator or competent.
No, not the arbitrator. Whether he would not have the power under the civil court.
The civil court, definitely civil court. But he is agitating on the basis of NHA. That is our prayer, Miller. That is our submission and prayer. If would have been civil suit, we would have not more problem. But he is coming under NHA and on the basis of NHA, he is passing the order. This is passing, or this is passing order. Miller.
Mr. Counsel, what has happened to these lands? And why are all these affected persons being given? Who are you?
I am for Punang Mile, that is government Gaura.
How does the Gaura appear for everybody?
My lord, in Haplang, my lord, there is a customary practice. One common village, my lord, it is under the Punang, my lord, that is GB, government Gaura. So the government Gaura have a right to represent the villagers, my lord. So that is the custom in the Haplang. And Haplang, my lord, the Administrative Justice Act and rules is applicable prior to 29th of July of 2017. After the judiciary is separated from activity, all civil and all criminal matters, my lord, before that, my lord, 29 July of 2017, taken up by the Deputy Commissioner and Additional Deputy Commissioner, civil and criminal both, even the bail application. When there is a party, one party is tribal and other party is non-tribal, such proceeding taken up by Deputy Commissioner. If both the party, claimant and other respondent might defend them, then matter will be taken up by the council court, district council.
I'm coming in 5 minutes. I'll dictate the judgment.
Yes. Session, then the report submitted.
So are you saying that this order is being passed by the competent authority?
Not by the DC, might, by the civil court.
How can the civil court pass after the order?
My lord, suit is pending. During pendency of the proceeding, my lord, survey completed, fresh survey completed, then land measured, my lord. Then, my lord.
Show me the notification by which the land has been acquired.
Yes, my lord. That is where I have annexed, my lord. All documents I have annexed.
Where?
I have not concealed any material fact before your lordship.
Show me the document.
Now, your lordship may kindly come to page 26. Page 26, annexure B3, my lord. Permission for holding joint spot verification with National Highway Representative Construction Companies regarding damage of land and standing properties affected due to construction of highway to be held on demand on onward the Kalimpisa, Longpur, Didalton. These are the three villages badly affected because of their encroachment.
No, Mr. Counsel, kindly come to one thing. Where is the document by which there is a declaration that this land has been acquired?
Yes,
Where is that document?
yes, I'm coming to that, my lord.
You
One-
come to
one
that
of the-
only.
One of 27, my lord. All
27.
documents I have annexed, my lord, page 27. Then, my lord, your lordship may kindly come to page conduct of fresh survey, page 29, conduct of fresh survey. Then, my lord, submission of report. Here, with reference to your letter cited above in connection with the message, I have the honor to report you that the Revenue Department has attended on the spot for fresh survey in the disputed area along with UW official National Highway representative as per order passed on Iman. However, the fresh survey could not be conducted on spot in the disputed village, so as the National Highway could not produce land acquisition plan map of this area. Now I'm coming to next page. Now page 33, my lord. Assessment of property.
Because the order does not show that the land has been acquired.
Yes, now I'm coming. After that, my lord, land acquired, my lord.
When?
That is, my lord, 30 July 2013.
That is the date of, no, that is the date on which, how can the land be acquired? It has to be by way of a declaration.
My lord,
Where is
here,
the declaration?
here in compliance with the order of the Honorable Court, MK Das Additional Deputy Commissioner, my lord, page 34. I have the honor to submit here with 20 numbers of assessment sheet and compensation bill as conducted spot verification fee estimate by so a kind perusal and further, my lord. 3 villages name mentioned, my lord, Kalimdisa, Didaudi, Longpur, and total area affected, amount of compensation. Now further, it may be pertinent to mention that the land is required to be acquired due to diversion of alignment while fixing ROW right of way by the contractor engaged by the National Highway. The additional land is acquired under Senate so and so. It is also fact that the consultant engaged by National Highway never consulted with the revenue official during fixation of right of way. It seems that they have fixed right of way as per their convenience. Consequently, such changes diversion will be taken place in many villages.
Mr. Counsel, kindly come to the point.
Yes,
kindly come to, do you have the National Highway Act?
Yes, yes, my lord.
National Highway Act stipulates a manner in which the acquisition will happen.
Yeah.
There has to be a declaration.
Yeah.
There has to be a notification. Where are those?
Already they have taken possession. They have started to use the land, my lord.
Understood.
Everything. Now National Highway says, my lord,
Yes.
if your lordship kindly see to
Yes.
3,
Where is the
my lord, 3H, my. Before taking possession, they are to deposit the compensation in the office of the competent authority. This is the law, my lord. But they did not do anything. Land not acquired. They are not deposited. They have taken the land. They have enclosed the land. They have used the land for 4 land, my. No, section 3H. They have totally violated. How they can go against the law, my lord? Law is equal to all. How they can violate the law, my lord? At their own sweet will, my lord. This is the wrongdoer, my lord.
If
They are
they
the
have,
wrongdoer.
no, Mr. Counsel, if they have done so, then you are to make a reference under 3G.
No, my lord.
Yes.
No, that,
yes,
my lord. Before that, my lord, when land not acquired, we have filed a suit in the regional court, my lord. Before the
Understood.
civil court. for
As of
damage.
now, the land has not been acquired.
That time not acquired in 2012.
Now also, where is the land acquired?
Land acquired that time, my lord, during pendency of the proceeding. After.
Where?
That
Where?
is,
No, Mr. Counsel, kindly appreciate there has to be notifications under 3A, 3D declaration. Where is it?
My lord.
You see, kindly, no, Mr. Counsel, kindly read 3D.
3D, my
Yes.
lord.
Where is the document?
That is, there is a provision for acquisition
where
for the
is it?
purpose of construction of 4 land.
Whatever may be,
National
where
highway.
is that? Where is
But
that
that
document?
law, they are there to comply with that law. They have waived, my
So,
lord.
is it your case that without any acquisition, they have taken possession of your land?
Yes.
If that be so, then it is a case by which you are to file a civil suit.
For damage.
For damage.
Yes.
Not for damage, for the purpose of compensation.
Compensation. That is why we have
But you
passed, my
cannot.
lord.
But you cannot move under this act.
Yes, definitely.
But you have moved under this act.
No, we have mentioned because that was our claim, my lord. We have pointed our claim because there is a provision in the National Highway Act for payment of compensation. So that reflecting wrong law does not vitiate a proceeding, my lord, because already.
But your entire edifice of your case is under this act.
Initially, my lord, these villagers have no idea what was actually happened with them, my lord. Whether land acquired, whether land used by National Highway, who is the contractor, who has done it, for what purpose done it. These are the information, my lord, are kept secret by the authority. So these villagers, my lord, they are laymen. They are not a prudent man.
Mr.
They have no
Counsel,
idea
tell me
anything,
one
my
thing. Whether the land has been acquired?
Land acquired?
Yes, the Dimahaso. The land has not been acquired.
Not acquired. It is mentioned there affidavit.
The land has not been acquired. So under such circumstances, you have to file a civil. This authority, he couldn't have exercised this authority. We set aside, give you the liberty, give you the period of limitation will be waived, taking into account. Heard Mr.
My lord,
the learned
my
counsel
lord, there
appearing on
is a
behalf.
specific provision for preferring appeal, my lord, before the High Court. He'll appeal against the order of the Deputy Commissioner, my lord. He is exercising his power under the provision of the local act and rules, my lord. That is why Deputy Commissioner passed a final order, my lord, in the suit, and that is the appealable order, my lord. But they have prepared a writ petition, my lord.
Heard Mr. Tiburwa, the learned counsel appearing on behalf of the petitioner. Your name?
DC Kathajurika.
DC Kathajurika, the learned counsel appearing on behalf of the respondent number 7, 8, and 9. Mr. A. Konikar appears on behalf of the respondent number 1, 2, and 5. 1, 2, and 5. 3 also? 1, 2, and 5. Mr. Swanso and Kusami appears on behalf of the respondent number 3, 4, and 6. The instant writ petition has been filed under the file challenging the order date 4/10/2013 passed by the Additional Deputy Commissioner Dimahasao District, Haflong, in Miss Case number 20/2012. It appears from the facts involved in the instant case is that on 28th of January 2005, the central government, by the notification under Section 3, small a, of the National Highway Act 1956, for short, the Act of 1956, authorized the Secretary, Revenue, NC Hills, Autonomous Council, Haflong, as the competent authority to perform the functions of such authority under the said Act of 1956, with effect from the date of publication of the said notification in the Official Gazette, in respect to a stretch of land from kilometer 66 to kilometer 244, bracket Lamding des Maibong des Harangjago section, bracket close, for building, maintenance, management and operation of the National Highway number 54, bracket including construction of bypass and realignment, if any, in NC Hills. Pursuant to that, the record reveals that the acquisition was done in respect to the said land. It appears further that the respondent number 7, 8, and 9, who are the Gaunguras of the respective villages, filed an application before the Deputy Commissioner Haflong under Section 3G7 small c of the Act of 1956 for determination of additional compensation for the land situated in Kahilim Disa, Kahilim Disa, Kahilimbisa, Didao Deep, and Longboard. As required for construction of the national highway and any other benefit entitled under the said law. The said application was registered, the said case was registered as Miss Case number 20/2012. A perusal of the said application as enclosed as Annexure 6 to the writ petition reveals that the National Highway Authority of India, that is the writ petitioner, had implemented the project for constructing the highway, which runs from Maibong town to in the north to Mohu town in the south, through villages of Kailim Disa, Didao Deep, and Longwe. It is the case of the petitioners. It is the case of the respondent number 7, 8, and 9 herein as applicants there in the said proceeding, that the highway was constructed by cutting the top hill ranges just by the side of the highway. Are the slope of the hills. On the eastern slope of the hill, the village Kalim Disa and Diadu, and on the western slope of the hill, the village so-and-so, Longor, are situated. It was the further case of the applicants therein that a promise was made to the villagers that only 60 meters of land would be affected, which means 30 meters from either of the existing PWD road. However, while making the construction, the National Highway Authority continued the earth cutting on the north non-acquired land, that is beyond the marks of the acquired land, due to unplanned construction, which caused heavy damage to the land belonging to the village of the petitioner, of the applicants therein. It has been further mentioned that the applicants thereafter filed objections dated 4/11/2009 and 18/6/2010 against such construction of the National Highway Authority of India before the Deputy Commissioner and the respondent number 4 respectively, with a prayer for making physical inquiries so that the affected villagers could receive their compensation without delay with proper evaluation under the provisions of law in force, that is under Section 3G(7) C of the Act of 1956. It further reveals that a notice under Section 80 was also issued. It has been specifically mentioned in paragraph number 7 of the said application that compensation was paid to the affected villagers only for the acquired land in terms with the notification dated 23/2017 without following the established procedure of law. It is under such circumstances, the prayer so made in the said application was for determination of additional compensation for additional damage caused to the land of the petitioner's village, in terms with Section 3G7C of the National Highways Act 1956, semicolon, additional compensation with interest as prescribed under the provisions of the National Highways Act 1956. To the said proceedings, it reveals that the petitioners herein had filed their written statement. In the written statement, it was mentioned that due compensation has been paid to the affected villages as per the assessment made by the Revenue Department of the Dima Hasao Autonomous Council. It was further mentioned that the writ petitioners are not responsible for the deposition of cutting debris by the construction company. And it is the sole responsibility of the contractors as per the contract provisions. It appears from the records that evidence were tendered and the learned additional deputy commissioner, Dima Hasao district, by an order dated 4/10/2013, disposed of the said application, that is Miss Case number 20/2012, by directing the petitioners herein to make payment of additional compensation to the tune of rupees 6,88,31,700 to the applicant, to the respondent number 7, 8, and 9, and other affected persons of the villages in question, It is against the said order that the instant writ petition has been filed. It is relevant to take note of that on 11/11/2013, this court issued notice making it returnable by 6 weeks. And the judgment dated 4/10/2013 passed by the Additional Deputy Commissioner Dimahasau District in Ms. Case number 20/2012 was stayed. It further appears from the records that the respondent number 3 has filed an affidavit in opposition on 29th of January 2014. In the said affidavit in opposition, it was the categorical statement being made by the Additional Deputy Commissioner Dimahasau that the writ petitioner had maliciously caused extensive damage to the non-acquired land and properties of the villages under the respondent number 7, 8, and 9 during the course of construction of the four-laning National Highway section of National NH 54E under the contract package number EW Roman 2 bracket AS-23 across the recognized revenue villages of the said respondents by using their men and machinery without proper care and attention. In paragraph number 4, it has been further mentioned that the Deputy Commissioner, the court of the Deputy Commissioner Haflong at Dimahasau at Haflong, while exercising the jurisdiction, had acted as a civil judge It was further stated that in the said proceedings, the petitioner's hearing never raised the issue of jurisdiction at any point of time. It was further mentioned that the additional secretary and the revenue officer, the Mahasau Autonomous Council, who is the competent authority to assess damage and to determine compensation, had submitted the assessment and determination of compensation report on 31/7/2013 and 12/9/2013 respectively, after joint verification of the affected land of the said villages before the court of law without the objection of the petitioners and their authorized contractor. It was further mentioned that it is the additional secretary and the revenue officer W of Dimahasau Autonomous Council Haflong who was the competent authority to do so, and not the secretary in charge revenue. The respondent number 7, 8, and 9 have also filed an affidavit in opposition on 22nd of July 2015. In the said affidavit in opposition, it is the specific stand taken that the writ petitioners have constructed the 4-lane over the non-acquired land by way of encroachment in the unplanned manner and dumped the unwanted excess earth, cuttings, gravel, soil inside the boundary of the village common land, for which extensive damage has been caused. The jurisdiction of this court under Article 2, the invoking of the jurisdiction of this court under Article 2 to 6 of the Constitution have also been challenged on the ground that there is an effective alternative remedy by way of an appeal. To the said affidavit in opposition, so filed by the respondent number 3 and respondent number 7, 8, and 9, the petitioners have also filed replies. It is, however, interesting to note that an affidavit of opposition has been filed by the respondent number 2 on 24/1/2023. In paragraph number 3 of the said affidavit in opposition, this affidavit in opposition is of vital importance, taking into account that the said affidavit was filed by the Secretary Revenue NC Hills Autonomous Council, who was appointed the competent authority. In paragraph number 3 of the said affidavit in opposition, it has been mentioned that the site mentioned by the petitioner seems to be beyond the right of way, and the Land and Revenue Department have not acquired the said site, nor the NH authority informed the Land and Revenue Department Dimahasau for such requirement of land for dumping purpose, and as such taking action as required under section 3G and 3H of the National Highway Act 1956 did not arise. It was further mentioned that the Standing Council of the NC Hills was duly intimated by a necessary communication dated 31/12/2022 wherein it has been mentioned wherein the contents of paragraph number 3 was mentioned. In the backdrop of the above pleadings, let this court take into consideration the respective submissions of the learned counsels for the parties. Mr. C. Burua, the learned counsel appearing on behalf of the respondent number of the petitioner submitted that a perusal of section 3G of the Act of (1956) shows that the determination of the amount payable as compensation as well as additional compensation can be only done by way of by the competent authority or the arbitrator. The learned counsel submitted that a perusal of the section 3a of the Act of 1956 duly defines the term competent authority as a person or authority authorized by the central government by a notification in the official gazette to perform the functions of the competent authority for such area as may be specified in the notification. In that regard, the learned counsel has drawn the attention of this court to the notification dated 28/1/2005, whereby the Secretary, Revenue NC Hills Autonomous Council, Haflong, was appointed as the competent authority. The learned counsel further submitted
Appointment of arbitrator in case 66.
that in terms with section 3G of the Act of 1956, if the amount so determined by the competent authority was not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government. The learned counsel therefore submitted that the central government had not appointed.
Arbitrator is appointed. I'm looking at the appointed
No.
arbitrator. Yes,
You listen, I'm not on that.
Sorry. No, I understood.
The learned counsel therefore submitted that the additional deputy commissioner who passed the impugned order was never appointed as the arbitrator. In fact, by the specific order passed by the Government of India, Ministry of Road Transport and Highway, dated 31/12/2001, the central government had appointed the Divisional Commissioner, Hills and Barak Valley Division Dispute, as the arbitrator. It is therefore the case of the petitioners that orders so passed by the additional deputy commissioner, the impugned order so passed by the additional deputy commissioner is an order passed without jurisdiction under the Act of 1956, and as such, the present writ petition has been filed. On the other hand, Mr. D.C. Natka Khazarika, the learned counsel appearing for the respondent number 7, 8, and 9, had submitted that initially the National Highway Authority of the petitioners had acquired some certain portions of the land, but subsequently when various other lands, which is the subject matter of the application so filed, were affected, and the application being Miss Case number 20/2012 was filed, the respondent authorities, in the petitioners as well as the respondent authorities, had taken steps for acquisition of the land. He, however, submits that the petition so filed was for compensation on account of the damage so caused to the villages of the petitioners of the application being Miss Case number so and so filed, was on account of the damage so caused to the villages of the respondent number 7, 8, and 9, on account of construction as well as cutting of the hills, which had damaged the land as well as the property belonging to the villagers of the villages of the respondent number 7, 8, and 9. The learned counsel further submitted that though in the order, further submitted that during the pendency of the instant proceedings and prior to the passing of the impugned order, the land was acquired. Mr. A. Khanikar, the learned counsel appearing on behalf of the Dimahasa District Council, submitted that the land in question, which was the subject matter of the proceedings in Miss Case number 20/2012, was not acquired.
But not based upon record. But a statement which they have made in their affidavit, not based on record. They have not annexed any.
You have also not given the
Yes,
report.
right.
Yes. Was nothing. Mr. N. Goswami, the learned counsel appearing on behalf of the Deputy Commissioner, Dimahasa, supporting the judgment so passed, supporting the impugned judgment and order, submitted that the said order was passed not in exercise of the powers under the National Highways Act, but was an order so passed in terms with as a civil court. And as such, the Deputy Commissioner, the additional Deputy Commissioner, had the jurisdiction to pass such orders, to pass the impugned judgment and order. Upon hearing the learned counsel for the parties and on perusal of the materials, Mr. Borua, don't you think this aspect of the matter can be taken into consideration by the arbitrator or by the competent authority?
This matter.
The damage which has been caused.
No, that is, if
Why?
it is, no, here, once by appealing by this petition, my lord, this impugned order.
That is, I'm not on that. I'm only asking you whether this damage which have been caused.
No, that is not, that's not fair.
Huh?
That is not to be taken by arbitrator, not
Why?
by arbitrator, because it is not come within NS 56, my lord. It's
I'm not concerned with, kindly come to 7B.
7B. 7B of my lord.
387B and C. National Highway Act.
B, 7B, 7.
Hmm.
It is 9 here, 6, 7. Put it. 8B. The competent authority, the damage if it is sustained by person.
And 7C?
Yes, yes. I've got it. The damage if any sustained by person interested. The time of taking possession of the land by reason of such land from that. Or
His other immovable property in any manner or his earnings. Why not this be
Yes.
taken into consideration?
Yes.
So you either appoint an arbitrator,
I already appointed.
appointed. So he will file an application there.
Yes.
He will take it over.
Yeah.
This will be done by that authority.
But only I have to say only because this arbitrator tend to be in this little bit getting changed. There is no arbitrator is appointed.
No, you have only appointed the office.
No, the arbitrator because district.
No, you have appointed the office, not the arbitrator by name.
Yes, yes, we'll take into this. As for whoever the arbitrator will do, because sometimes it may get changed. So that is why.
No, change on
Arbitrator will be
it
there.
will continue.
Arbitrator will be there. Yes, definitely. Whoever arbitrator, my lord. Whoever be arbitrator, present arbitrator, will go.
কি লিখলে? It transpires that if there is a damage caused, damage sustained by a person, interested at the time of taking possession of the land by reason of the acquisition, injuriously affecting his other immovable property in any manner or his earnings, it is the competent authority or the arbitrator who can decide in terms with section 33 G7C. Good stop. In the instant case, the damage which has been caused as alleged to the villages of the respondent number 7, 8, and 9 on account of the acquisition or for the purpose of affecting or on account of the work carried out by the National Highway Authority of India through its contractor, in the opinion of this court, would come within the ambit of Section 3G7C of the Act of 1956. Accordingly, this court, taking into account the mandate of the Act of 1956, which only permits such decision and such determination to be done either by the competent authority or the arbitrator so appointed in terms with Section 3G5. The passing of the order by the impugn order by the Additional Deputy Commissioner, the Mahasau District, in the opinion of this court, is in excess of the jurisdiction conferred upon him by law. Accordingly, this court therefore sets aside the order dated 4/10/2013, passed by the Additional Deputy Commissioner, the Mahasau, in Miss Case number 20/2012. Next. Taking into account that there is a dispute which requires a determination this court directs the competent authority, that is the Secretary, Revenue, the Mahasau Autonomous Hills, no, he cannot exercise the power under 31(3)(g)(7)(c). Directs that the records pertaining to Miss Case number 20/2012, this is the records. Huh? Determination. Come. The arbitrator so appointed by the central government in terms with its order dated 31/12/2001, that is the Divisional Commissioner, Hills and Barak Valley Division Dispute, is directed to determine the said dispute as regards the entitlement of the petition of the respondent number 7, 8, and 9 to any additional compensation on account of the land, their land, their land as well as the land of the villagers being affected due to the acquisition made by the National Highway Authority of India in terms with Section 3G7C of the Act of 1956. The respondent number 7, 8, and 9, the petitioners herein, as well as the competent authority shall approach the respondent number 7, 8, and 9 shall approach the divisional you approach. The petitioners you will approach.
Petitioner will be there. They will have to approach.
Huh?
I think they have to approach by this all this document. Generally, they approach, petitioner approach, will
No, you see, why I'm saying is, if the amount determined by the competent authority under subsection 1 is not acceptable, either of the parties, the amount on such an appeal by either of them be determined by the arbitrator to be appointed by the central government.
I do
Okay.
either. That is why
The respondent number 7, 8, and 9
they are affected.
is directed to approach
My lord,
the divisional commissioner, Barak Valley, so and so, this full Guwahati.
Hills and Barak Valley Division.
Hmm?
Hills and Barak Valley Division.
Is given the liberty to approach the divisional forest authority. Who shall thereupon determine the dispute in accordance with the Act of 1956. The records which have come, which have been called for, is returned to the office of the Deputy Commissioner. Deputy Commissioner. De Mahasau. Who shall upon due application and who said this matter has to be sent from here, these records. We are going to approach, na?
my lord. Definitely, my lord.
Then why I'm saying is these records, I don't want a new fresh application to be filed.
Yes,
These
that is
records
go
have to
to
go.
revenue, my lord. Revenue Department demands the autonomous council.
No, then the problem arises, na? It's sent to
But
the,
here, my lord,
no, these records, where should I put?
go to demands the autonomous
Demands,
council, my lord.
He will call.
Because deputy commissioner in Haflong is not a collector. So there is a council, my lord. Council deals
Shall
with the
be,
land department,
the records herein shall be sent back to the Dimahasau,
land revenue department.
to the revenue department of the Dimahasau Autonomous Council, who shall
And the
place the records before the divisional, before the arbitrator, that is the divisional commissioner, Barak Valley so and so, when the said would be called. It is made clear that the said proceedings, that if the petitioners, respondent number 7, 8, and 9 approaches the divisional commissioner within a period of 3 months from today, such approach shall be taken as a continuation of the proceedings, that is Miss Case number 20/2012.
My lord, already competent authority determined compensation in respect of 3 villages. And my lord, 3 villages that competent report, competent determination of the report of the competent authority that not challenge it a reproceed.
Not necessary. All these things you take the benefit there.
Yes, my lord.
You take it. That is why I'm not touched on merits.
Yes, that part.
I'm not touched
open,
anything on
my
merit. I am only touched on the jurisdiction.
Yes. Now my lord, question is My lord, that can be determined, the entire thing can be determined by the competent authority, my lord, by the
No,
secretary.
competent authority can't decide. Competent authority is only in respect to the land. That is why I didn't send
Yes,
it to the
yes.
computer. But the arbitrator can decide the other aspects.
That is the compensation part,
Yeah.
determined by the competent authority.
But
my lord.
no, the competent authority can't. It is only by the arbitrator. Because arbitrator exercises the power under 3G5.
Yes. So, the determination made by the competent authority, which is in record, my lord, that is remain in force, my lord.
Mr. Kathajorika, I have not touched on anything on
Yes,
this.
my lord.
I am only touched on the jurisdiction.
Yes, my lord. Now, within 3 months, my lord.
You approach. If you approach within 3 months, it will be taken as a continuation of the earlier proceedings.
Yes, my lord.
Otherwise, your limitation is the question. No?
Yes, my question, my lord. Here, man, it is mentioned that if either of the party, suppose our compensation determined, and we have satisfied with the compensation determined by the competent. Suppose 7, 8, 9 satisfied with the determination report of the competent authority. Then they are to go to arbitrator, my lord, in such situation. This is the law, my lord. They are to go to the competent arbitrator, my lord, because either of the party, my lord.
Therefore, I am saying here you have not been paid a single penny by the
No,
arbitrator. So
definitely.
therefore, there is a dispute. So you are going to go to the arbitrator. Now the arbitrator, therefore I say that there is a dispute. So I have asked you to go to the arbitrator. Who shall decide? Yes, Mr. Barbara, sorry to keep you waiting. These matters have to be finished off early.
I almost finished the argument. There is a set of rules. Panchayat, there is a hierarchy of officers. The PDOs, we are on top of the PDOs. From PDOs,
No, I understand. No, I only asked them on the last occasion
ROP.
to find out that me the ROP.
ROP is minor. I have got it. ROP.
Yes, is there anything in between?
My lord, ROP is 2017 says grade pay is the
45.
fixed amount corresponding to the pre-revised and revised grade pay. Revised basic pay, pay drawn in the prescribed pay band plus the applicable grade pay. So no problem for my lord, your lord.
No, only worry which the finance had, that if 13,300 is what I think the these people are getting, no?
They are getting 12,700.
Whether 13,300 if it is given, how many others are there?
Our appointing authority has recommended for us 13,300 because
Where is it?
both the cadres cannot have the same grade pay, my lord. At
Yes.
page 55, lordship will find the videos salary, page 55, grade pay of the videos. This was done in my lord, February 21, impugn order. It was my lord,
We are
enhanced
concerned with the directorate of Panchayat.
to 12,000 commissioner.
No, are we concerned? Yeah, Panchayat and Rural Development.
Yeah, Panchayat and Rural
Here the
Development.
grade pay is joint director is 15,100.
Yeah.
Deputy director is 14,500. Assistant development commissioner is 13,300.
Yeah.
Principal composite training area is 15,100. Vice principal composite is 14,000 a year. BDO is 10,900.
That was earlier. My lord, lordship may have a look at page 55 annexure.
Now it is what?
Video now it is 12,700. Same as ours.
BDO.
Yeah. Can you see page 55?
And that post is not there.
ROP, this ROP is of 2017.
No, where is that that petition? Your post is
Our post is chief executive.
deputy chief.
Deputy chief executive. We have been promoted from the post of video in the year 2016. Now we were getting higher than minus by this.
What is this post of assistant development commissioner? Where is the PNRD?
Minus the hierarchy is your lordship will find.
It was there.
In the rules. In the rules, my lord. Page 36. Assistant Development Commissioner has been, my lord, given to the Panchayat teacher.
Additional director.
Yes.
Joint director, deputy chief executive officer. We are D.
Yeah.
Assistant Development Commissioner. Oh, so he's lower in rank.
Is a lower in rank. Even he is getting. He belongs to fishery. He has been earmarked in fishery.
A person who is lower in rank is getting more.
No, what the striking factor that I have noticed in this my lord ROP roles pertaining to the NRA department is that it doesn't mention about the post of CEO or deputy CEO. And that is the precise reason why my lord the pay commission had made that recommendation. That my lord will once again come to my lord page 50 of the writ petition, page 50 of the writ petition. And acting on the recommendation of the pay commission, the finance department has taken the call.
Where?
My lord, clause number 8, page 50, down below the second last paragraph.
Page 49 is it better copy.
The post of deputy CEO, BDO senior grade and BDO shall be put in the same pay scale with GP of grade pay rupees 5,400. The designation of BDO senior grade be abolished and the officers posted in the Zilla Parishad be called deputy CEO and those posted in the blocks be called BDO.
Others may go, huh? This is the last item.
My lord, the cases basically, my lord,
both having the same grade pay of rupees 5,400. As a consequence of this, the EO Group B can be posted on promotion either as Deputy CEO or as BDO.
This stage, it will be subject to the service rules. What, my lord, the commission may recommend something which the government may accept, may reject, may partially accept and partially reject. Here, my lord, paragraph 1, 2, 3, on page 49. Page 49 is a better copy, type copy. Lord, you may have a look at that. Page 8, paragraph 8. Post of deputy commissioner, deputy executive officer, senior grade, and BDO shall all could be in the same pay grade with 5,400. It's a ridiculous proposal, if I may submit so. Designation of BDO, senior grade be abolished, and officers posted in Jilla Parishad be called deputy chief executive officer. We are already both having the same DAGP. This cannot. EO. And then it is not necessary. EO is the last step. Then, my lord, it says, it says that it will be subject to government's acceptance. Lord, you will find. Relevant expected page 51. Page 51. Panchayat Rule Act. The provisions of service rules shall apply in the recommendation of the commission at subparagraph 568. So therefore, service rule will be the paramount thing. Service rule will be, it cannot override. As per service rule, we are higher in the anarchy. Therefore, our appointing authorities have recommended us. It is the finance department who is at loggerhead. They are, my lord, giving a veto to it, my lord. Here comes the violation of, my lord, Article 14, basically, my lord. And here I actually wanted to cite and conclude. This is a case of unequals being created equal. It is a straightway case of being unequals being created equal.
As per the service rule, this assistant development commissioner is lower in rank? No.
Page, my lord.
Page 36.
Page 36.
Yes, it is lower
Now,
in
how
rank.
does a person become an additional deputy commissioner? Development commissioner? How does it happen? Additional deputy commissioner?
My lord, additional
Development commissioner?
assistant development commissioner from block development officer and deputy chief executive. In between, my lord, lordship will find assistant development commissioner, panchayat and rural development. And that has been here. That has been sent to the, my lord, wing of, my lord, panchayat officer. Panchayat.
Where can I find the assistant development commissioner? Which rule?
That has been, my lord, to my knowledge, my lord, that has been given to my lord, fishery.
Oh, fishery.
Otherwise, my lord, lordship will kindly turn to page 39. It says,
So fishery will be outside the PNRD.
I cannot.
it is a different stream, my lord, the panchayat will know.
As far as the cadre of officials are concerned, it's mentioned in the Assam Panchayat and Rural Development Officer Services Rules 2013, madam. It's in section 3.
Section
3, madam.
Yes.
Cadre. So they provide, madam. And at A, it is additional director, then B, joint director. There on, my lord, the CEO is at, deputy CEO is at serial number D, madam.
Yes.
And the BDO is at F.
Of officers have been, my lord, called out. Thereafter, my lord, this pay commission was constituted. And the pay commission has taken, my lord, all the objections from all the stakeholders, which my lord will find at page 50 once again, my lord. Kindly see, my lord. Page 50, my lord, the second paragraph. Page 50, the second paragraph, my lord.
Yes.
Memoranda have been submitted by 5 different associations, namely all Assam BDOs Association, all Assam Panchayat and Workers Extension Officers Association, all Assam Rural Development Employees Association, all Assam Gao Panchayat Secretaries Association, and all Assam Panchayat and Rural Development Fisheries Development Officers Association, which include demands which are interconnected and require reorganization of pay and resignation.
Understood, Mr. Borpujari. Everything is understood. But if a statutory rule remains, can you do anything?
So therefore, my lord,
So you have to do one thing. You have to either say that, okay, these people, the DO, deputy chief executive officer will remove it and we'll make more CEOs or whatever maybe.
Yes, that is.
You have to do something.
Yes.
The rules have to, otherwise, wouldn't that be unequal pay when it is a promotional pay?
No. So therefore, these 2013 rules must have been placed before the pay commission by these objectors, my lord. And having considered that rule, therefore, my lord, the pay commission has recommended.
Understood, but if the pay commission makes a mistake, is it you cannot touch it?
Pay commission has said, my lord, therefore, my lord will kindly turn to page 51. Page 51, their language, I do not know how it is written in such a language. Down below, my lord, the provisions of service rules shall apply in recommendation of the commission in subpara 4758, meaning thereby, what I understand, my lord, the PNRD may have to amend the rules. And this is what exactly, my lord.
Understood. Let us assume the PNRD have to amend the rule.
Yes.
But a vested right which have accrued upon them on a promotional post, can the PNRD do so?
No, if the rule is
you amend it. The PNRD may tomorrow remove the deputy chief executive officer, no problem with it for that. But what will happen is regards the petitioner who have already got the promotional post.
For great pay, they don't have to amend the rule. For promotion, maybe.
But the pay commission has taken the financial implications on board. And
there are many cases where, Mr. Borpujari, you find out that if there is some problem in doing it, you can, from these posts are removed and those posts are again adjusted with a higher post or lower post, whatever may be. That is the, in fact, that is the recommendation. They remove the CEO or deputy CEO and amalgamate it with the BDO. That is the recommendation. But whether the recommendation has been followed, and that recommendation was given at 5,400. Earlier one.
So they have not followed.
Understood. If they have not followed the rules, if they make it, isn't it done under the year or aegis of the government?
My lord, this is what the pay commission says, because my lord,
No, pay commission cannot be the above everything. When the rules say that, they have to take note of that.
Pay commission will go by the ROP rules, because my lord, ROP rules was, my lord, on 2017. It was notified in the year 2017. If there is already an existence of a statutory rule, that is, my lord, 2013 rules, which my lord will find at page 35. My lord, this post ought to have been incorporated in the ROP rules, but it has not been done, because because of the recommendation of the pay commission.
So
Because of the
how does it
recommendation.
matter?
No, because what post, the nature of job done, my lord, everything is taken on board. Everything has been examined, and therefore, my lord, the pay commission has made this recommendation. Now, if my lord, what I understand, my lord, subject to correction, the recommendation is that, my lord, you abolish this post, and therefore this post has to be abolished. There cannot be any promotional post. They might have been promoted, my lord. They might have been promoted, but
They were promoted in 2016.
maybe might have been promoted.
So you want to demote them?
This is what the pay commission says. I cannot tell beyond it.
The commission says or not says, how does it matter? Can the pay commission say that the rules, maybe the service rules to be violated? The pay commission has not said.
No, service pay commission has made recommendation, and finance department is bound by the recommendation of pay commission.
No, they are not bound. They may accept or may not.
No, they
Show me that particular provision where you say that the finance department is bound by the pay commission. Show me anything.
No, Lordship may kindly take up my affidavit, my lord. The finance, the affidavit filed by the finance department.
Yes.
It starts from running page 81. Lordship may kindly come to running page 101. That is what, my lord, I had drawn my lord's attention on the last occasion also. This is the final endorsement. This is the decision of the government at the finance department.
101.
101, Annexure E.
Yes, what
This,
is it?
this is the finance, my lord. Finance PIU department observes that the 7th APCC Pay Commission, after thorough in-depth study and examination, had recommended that the post of CEO, BDO, senior grade, and BDO should be in the same grade pay, revised 12,700. The designation of BDO senior grade should be abolished and so. After received the proposal from PNID department for upgradation of grade pay of BDO, and there being recommendation of 7 so and so. For upgradation of grade pay of BDO so and so, the pay scale of the post be enhanced to so and so by notification so and so. They are having no recommendation for upgradation of grade pay of deputy CEO. PNID department was requested to examine and take action as per recommendation of 7th APCC and amend the service rule if required. This is what, my lord, I am trying to, my lord,
understood.
Yes. Then no action on amendment of the service rules had been taken by the department, and the department has justified the upgradation on the ground that deputy CEO was created as promotional post from BDO, due to which recommendation of 7 APPC could not be followed. And if the recommendation of 7 APPC is acted upon, it would be anomalous. However, if the recommendation of 7 APCC was an anomaly, department ought to have placed the matter before the anomaly committee, but it did not. PNID department again resubmitted the proposal justifying the upgradation in view of manifold responsibilities of deputy CEO. PNID department also stated that there are 44 sanctioned posts of deputy CEO, and at present man in position is 9 and remaining 35 posts are vacant. In view of the above, PNID department is requested to clarify if there are other posts under PNID department with grade pay of 13,300 and the possibility of those incumbent again coming for higher pay if the grade pay of deputy CEO is updated. PNID department may also furnish the financial implication. Further, PNID department is requested to re-examine the above proposal in view of the recommendation.
So PNRD, why don't you give them 13,300? What is the problem?
My lord, one thing, what the document that he has read, that 7th Pay Commission in-depth study, and this endorsement by the finance, all of them, my lord, ignored one piece of document, which is at page 20. Page 20.
Of your petition.
Of 29 of document.
Yes.
Making all of them equal. In-depth study, they have ignored this piece of document, my lord, which was of 2016. In the interest of public service, Governor plead to promote the undermentioned block development officers to the post of deputy chief executive officers. The addition of their new substantive post, the promoted block developments are directed to whole addition and charge. So this is an order which clearly shows that from the post of PDO, we were promoted, and this vital document they ignored, and they said we made an in-depth study. Definitely they cannot be given the same pay grade,
Great.
Now how much is CEO getting?
CEO is getting 12,700.
CEO.
No, these videos are getting.
No. CEO.
CEO, my lord, recommended. We are getting the same 12,700, and videos are also getting the
No, there is
same.
no CEO in the
There is no
cadre.
CEO.
Yes. Deputy CEO.
All the petitioners are deputy
Lordship.
CEO.
No.
Page
Whether there is a
55.
CEO.
There is a designation of.
Page 55.
Where? In the cadre there is nothing.
Page 55, Lordship.
No, page 33, there is no cadre CEO.
My lord, it is here. Page 37, clause 454. Recruitment to 100% strength of deputy chief executive officer shall be made by promoter.
No, that I have got it. I'm only asking, where is in the rules, where is the post of CEO?
There is no. Next post may be joint director or deputy director.
But they have a post of CEO.
They have.
How are you paying them?
That amount, I don't know.
But because that is not there in the ROP.
No.
ROP doesn't mention about neither CEO nor deputy CEO.
Then
It only mentions about, my lord, the BDO. BDO, then, my lord, additional director, joint director, deputy director, principal composite training center. Everything is, my lord, everything finds a place of mention in the ROP. 7 except, my lord, this the designation of CEO and deputy CEO.
So the basic fact, basic thing is, my lord, that we having been promoted from the post of BDO, we cannot be given the same.
Mr. Barbara, you are okay with 13,300?
Lordship.
You are okay with 13,300?
Yes, my lord, that's what, my lord, my employer has recommended. In that case, my lord, I wanted to cite, because we have also impugned, my lord, pay commissions, this paragraph 8. Although it says that service, it talks about service rules. The government talks about government. While handling, my lord, the recommendation.
How many posts are there in the deputy CEO now? 9.
This is what, my lord, the finance department endorsement says. And lordship, if my lord is taking up, my lord, this.
How many petitioners are here?
Here we have 10, my lord. 5 already retired, my lord, during the pendency of this case. And, my lord, now about the pension calculation, it is, my lord, the pension is being calculated based upon the 12,700 grade pay. That lordship will have to direct them to not pay the grade pay of 13,000 so and so notionally with effect from the date when the video's grade pay was announced. That will have to be the court's interference in this case because of violation of Article 4 state. That's my. And let me cite, my lord, few decisions which might come handy for your lordship, my lord. How Supreme Court and time and again, my lord, discarded the practice of treating, my lord, equals, non-equals as equals. It is precisely what has happened in my case. Promotion is a different thing. They might have to amend the rule or might have to find a supernumerary post. That is a different. Kindly see this.
Yes.
This is, my lord, Mewaram. Lordship may kindly turn to page 239, paragraph 5 and 7. Page 239, paragraph 5. While considering the question of application of principle of equal pay for equal work, it has to be borne in mind that it is open to the state to classify employees on the basis of qualifications, duties, and responsibilities of this post. If the classification has reasonable nexus with the objects sought to be achieved, efficiency in the administration, the state would be justified in prescribing different pay. But if the classification does not stand the test of reasonable nexus to the classification is founded on unreal, unreasonable basis, it would be violative of 14 and 16 of the Constitution. Unequal cannot claim equal. This is my case. And then paragraph, my lord, 7, page 241. Here, my lord, even assuming there were two types of, my lord, employees,
In between paragraph 7, my lord, middle portion, even if the duties and functions are of similar nature, but if the educational qualification prescribed for the two posts are different, then there is difference in the measure of responsibility. It takes the extreme position. Here we, my lord, teacher, higher responsibility. Next page, my lord, 242. Roundabout middle, below the box. A comparison of the qualification prescribed for the two posts clearly indicates that higher qualification is prescribed for the post of audiologist. There appears to be quantitative difference in the qualitative difference in the responsibilities of the two posts as an audiologist possesses higher qualification. It is therefore manifest that on the basis of education qualification, two posts cannot be equal. Even if the functions and duties of two posts are similar, it is open to the state to prescribe different scales of pay on the basis of different treatment to persons belonging to same classes. Are the videos and my lord the then my lord the next case, my lord, 2015 3 SCC. It is my lord Union of India versus lot of employees, my lord. 2015 citation C2 2015 3 SCC 653 Lordship may straight will go to paragraph 30.
30 they have repeated that memorandum, no?
Yeah. Lordship knows about it, my lord. Even then, paragraph 30, it makes it very clear. Referring to memorandum, it says following. While considering the question below, my lord, the quoted portion. But if the classification does not stand the test of reasonable nexus and the classification is founded on unreal and unreasonable basis, it would be violative of 1416. Equality must be among equals. Unequals cannot claim equality. 12,700 cannot be for both of us. Then, my lord, the third case, 1994, volume 2, Shyam Babu. Shyam Babu, 1994, volume 2, 521. Lordship may go to page 525, 525, paragraph 9. It was they are on behalf of petitioner that so and so equal, but they were entitled to. It was pointed out that so and so come below, my lord. The principle of equal pay for equal work should not be applied in a mechanical and casual manner. Classification made by a body of experts, supposing, my lord, the pay committee, are fully studied and analyzed, the work should not be disturbed except for strong reasons which indicate the classification made to be unreasonable. Inequality of men in different groups excludes applicability of the principle of equal pay or equal rule to 10. Paragraph 10 also. In the facts of the present case, there is no scope for applying the principle of equal pay for equal work when the petitioners belong to a separate category of pharmacists with reference to qualifications. According to us, there is no element of arbitrariness in the decision of respondents to implement two scales. It does not violate any of the provision it has said. Paragraph 11. Although we have held that the petitioners are entitled to the pay scale of 330-40 in terms of recommendation third pay commission, with effect from so and only after a period of, they became entitled to pay scale, but as they have received the scale of Imam since 1973 due to no fault of theirs, and that the scale is being reduced in the year 84 with effect from January, it shall only be just and proper not to recover. It is about recover. Here, my lord, we don't grudge, my lord, the paying an enhanced pay to the PDO, our younger brother. We have not changed that. Our simple prayer is that we must not be paid. Since their pay has been enhanced, we are entitled to be enhanced and data. Then, my lord, 2008, volume 10, Supreme Court. Next case. Then this is the last one, my lord, where the Supreme Court has formulated the basics for such classification. This is, my lord. Lordship is taking up 2008, volume 10.
Yes.
Kindly turn to, my lord, page 151. Paragraph 35, 36, 37. 35, we have already dealt with the scheme of statutory regulations. The higher post of superintending engineer and above chief engineer level so are to be filled by way of promotion only on merit. Precisely for that reason, regulations provide for consideration of cases of executive engineer by a DPC and placement of executive engineers either in category on the basis of marks obtained by them. In our considered opinion, placement of executive in category 1 and category 2 is lawful reasonableization. Then 36. It is well settled under that Article 14 is designed to prevent discrimination. It seeks to prohibit a person or class of persons from being singled out from others similarly situated or circumstance for the purpose of being especially subjected to discrimination by hostile legislation. It, however, does not prohibit classification if such classification is based on legal and relevant consideration. In our case, it can never be relevant considerations, my lord, if this is the classification they are making. 37, my lord, formulates the, my lord, basic principle. Every classification to be legal, valid, and permissible must fulfill the twin tests, namely, the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group. Such differentia must have a rational relation to the object sought to be achieved by the statute or legislation in this case. The instant case on board before your lordship, my lord, equally, I should, my lord, humbly submit that these decisions squarely apply to the instant spectrum of my case, and irrespective of what the pay commission has uttered, my lord, we have impugned the pay commission's recommendations per age also, and government's fail to understand that everything was government itself said that it will be subject to the rules, and the rule said that we are higher than the CEO, and therefore Panchayat, my lord, commissioner very rationally recommended that our grade pay should be enhanced to 13,003. Rest will be for your lordship. So my prayer is, my lord, a prayer person kindly, lordship may see. I have not gone out of the track to make my prayers, my lord. Prayers. Page 24, 25. 1. You should read in the nature mandamus to enhance the grade pay for the post of Deputy Chief Executive Officer under the Panchayat Development Government to rupees 13,900. That was recommended at page 16. With effect from the date from which the block development officers have been given enhanced pay of the grade pay with all consequences. If 5 of the lead petitioners retired during pendency, my lord, lordship may observe that I have, my lord, indicated.
Now, Mr. Corpusary, tell me,
yes,
why did you increase the block development officers amount to 12,700?
12,700. It was there in the ROP as per recommendation of the pay commission.
No, if you the ROP which you have given is 10,900.
You know, it was pre-revised. Now it has been revised.
Where is it? No, you have given me a thing which is pre-revised.
No, it
Where is it? Revision.
No, it is a revised, my lord.
Then if why is block development officer is getting 10,900?
Yes, I also fail to
Then
understand. It is 10,000.
the problem, all problem areas is because of that.
No, lordship will kindly see, my lord, page 283 in the instructions. Instructions. Top of the page, my lordship will find page 283.
Yeah.
Yeah, there, my lord will kindly see, my lord, on left hand side, senior block development officer. They have been given 12,700. Senior block development officer.
That is a different department.
No, PNID.
Yeah, this is director of rural development.
Yes, PNID, Panchayat and Rural Development.
Then why you are giving them the? Is this being given to the senior development officer? This particular document which has been enclosed here, kindly see page. Yeah,
Last page.
23rd of February 2021. You are naming it as block development officer. Annexure 5, page 54.
Annexure 5, page 54, my lord.
Yeah.
Annexure 5, page 54, yes, block development.
You are
officer.
not putting it senior. Why are you giving it
Yes, yes,
12,700?
12,700.
Why? For senior block development officer, it is okay.
No, it is with, it is in pursuance of the recommendation of the pay commission, because earlier in the upper part, my lord will kindly see, in exercise of the power conferred under, so Article Governor was saying, following amendments shall be made to the schedule of so-and-so published in so-and-so, so-and-so. In the pay schedule under the head, Panchayat and so-and-so, below the subhead, Directorate of Panchayat, following existing entries, column 4 and column 5, page 562.
No, why have you done that?
No, that was done in pursuance of the recommendation.
Where is the recommendation?
The
The recommendation does not say anything to that effect.
No, recommendation, my lord, we are now only dealing with the issue of whether my lord
No. The problem arose because you have given that. Earlier it was as per the recommendation, it was 10,900.
Yes, something is written.
Why have you made it 12,000? It is only for senior block development officer. If that would have been there, then they would have been getting 12,700. Everything was not a problem. You have caused all the problem. Why have you given to the block development officer? Here you can deviate, but not there. Tell me.
Here, my lord, I don't.
Then
How come?
you have caused all the problem and now that happens everywhere. If you have not done this, no problem was there. You could have very well said that those are only for senior block development officer. Yeah, you can do this, but not that.
My lord, they will kindly give me. No, my lord, here, yes. Yeah, the grade pay. Grade pay is, my lord, 4,700. Pay band, my lord, Lordship will not go by the pay band. Lordship will see the grade pay. Yes.
I am only on the grade pay only.
Yeah, grade pay it is 4,700. At page 54. Page 54, 4,700.
Then straightway enhanced to 12,700.
No, that is the pay band.
No. Finally, say page 54. You see,
Grade pay.
8,000 to 35,000.
Yes, column
This
5.
is the same at page 278, 8,000 to 35,000,
Yes.
which have been increased to 43,000 to 1,10,000.
And grade pay 12.
This is ACS is there. So this has increased to 10,900.
They have, yes, my lord. There is a gap. Because this cadre is born out of, my lord, ACS.
Hmm.
This cadre, the bunch of documents which I have now placed before my lord,
Hmm.
the pay structure here 278, my lord will kindly see at the topmost corresponding pay of ACS. These are, my lord, ACS born officers. Petitioners are not born out of, my lord, they are not ACS born
That's
officers.
correct, that's correct. But what about
Yes, there
55?
lies the catch. There lies the catch.
What about page 55?
But then tell me,
Yes,
the senior block development officer
yes.
is 5,400.
Senior block development officer, my lord is referring to which page, my lord? Yes, 283.
It's 5,400.
5,400, yes, my lord.
And that is, and block development officer is 4,700.
4,700.
Now you have increased this to 12,700.
4,700 block development officer, yes.
Although the corresponding at that point of time was 10,900, it should be for the ACS.
Yes.
You have increased it. If you see the senior block development, 12,400, 40,000, 5,000, maybe for 30,000, and then this is corresponding is 12,700.
Yes.
Why have you done that?
So this is with regard to that ACS bond.
Understood. That is why you are giving the benefit out there, the
Yes,
same.
yes.
If you come to page 278,
Yes,
it is in payment 3.
yes, payment fee.
Okay, so payment 3 in respect of 8,000 to 35,000, which was there,
My lord,
and the corresponding of 4,700 have been increased to 22,000, 8,700. The corresponding rank was 10,900.
yes,
Great pay.
yes.
Now you have increased this to 12,700, which is for the senior subdivisional.
No, it has been increased to BDO, and therefore it is.
Understood. This BDO, you
Yes.
are giving them the same as subdivisional planning officer.
Yes, because of the recommendation, because the commission, pay commission recommended that you abolish senior grade pay and put video in the same place. That is why this has come.
Now unless the abolishing doesn't happen, then how can you keep on doing it?
No, abolishing they will have to do.
Till date, but he has already acquired the rights.
Rights may be acquired. My lord, I am placing a decision of the apex court. Lordship will kindly say pay parity.
What does it say?
How it is to be dealt upon. Lordship, that I am relying on 2019-18 SCC.
Where is it? What does it say?
301. Well, this is Bihar Secondary Research Struggle Committee. Well, I am having the monopatra version and para 68. The apex, this is a case related to pay parity. Now, there were contractual teachers in the state of Bihar and regularly appointed. This category of teachers were claiming the similar.
No, how can you have that analogy out here? Here is a case where the person concerned is in a higher as per the service rules.
Yes,
You show me a judgment to that effect that in spite of that also in view of the ROP, you cannot pay.
Now, my lord, what are the parameters which is to be taken into account for fixation of pay? More so vis-a-vis, my lord, the issue of pay parity. I am only submitting on that. Possible apply on the facts and circumstances of this case. My lord, I am shortly reeling it, my lord. Analysis of the because apex court has referred to various decisions here. Analysis of the decisions referred to above shows that this court has accepted the following limitations or qualifications to the applicability of the doctrine of equal pay for equal work. Number one, the doctrine of equal pay for equal work is not an abstract doctrine. Number two, the principle of equal pay for equal work has no mechanical application in every case. Then, my lord, the very fact that the person has not gone through the process of recruitment may itself, in certain cases, make a difference. This is what, my lord, the ROP rules provide for. My lord, the selection process has to be taken into account.
We have a promotional post.
Sir, please move over there, sir.
We have promotional post.
Sir, move over there, sir.
Recruitment.
Sir.
We are promoted.
The application of the principle for equal pay for equal work requires consideration of various dimensions of a given job. Thus, normally, the applicability of this principle must be left to be evaluated and determined by an expert body. These are not matters where a read court can lightly interfere. Granting pay scales.
Lightly, na?
Lightly. Granting pay scales
Okay,
is
okay.
a purely executive function.
I'll take it up on Thursday. I'll dictate the judgment in your presence.
In the affidavit, we stated actually the.
You just find out what does the CEO get. Mr. A.K. AC Borbora, the learned senior counsel, assisted by Mr. R. Borbora, appears on behalf of the finance department, Mr. N.K. Devnath, appears for the PNRT, and Mrs. S. Borbora appears for the.
Number 4.
That is that who created all the problem?
Yeah.
Or who is respondent number 4?
Personal department.
There, personal department. Hearing matter has been heard at length. Let the matter be again listed on Thursday. Thursday after the top of the list matters.
Day after tomorrow. Yes.
After the top of the
Yeah, that's I'm so grateful, madam.